You are going to be pleading no contest to the charge of assault and/or assault and battery. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. You understand that, sir?
Yes, Your Honor.
Understand what a no contest plea is?
Yes, Your Honor.
All right, two things about it I have to make sure you understand. First thing is it means that you're not further desirous of wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Basis for a no contest plea?
The potential for civil liability. In fact, the likelihood I was contacted by a civil attorney.
Okay. Sir, to the charge of assault or assault and battery, how do you plead?
No contest.
Do you understand that by pleading no contest, you will not have a trial of any kind?
Yes, Your Honor.
All right. You signed an advice of rights form. Is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be pleading no contest. You're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
Understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25-24058. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, the court would not be bound by any sentence evaluation or agreement. You understand that, sir?
Yes, Your Honor.
Would not be entitled to withdraw your plea. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
Have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. And court having accepted the defendant's plea, defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
April 22nd.
April 22nd, 2026. Is that at noon? 9 a.m. Bond with its conditions will continue. Thank you.
Thank you. Your Honor.
Or make sure to stop down at my probation department on the left as you go down the hallway.
I'll walk you down there just for things outside.
Just 15 probation. Good 29th at noon.
You want me to get him back here?
I said, no.
I'll fix that.
Ralph, 1 second.
Your sentencing is at April 29th.
At noon.
At noon.
That conference. Yes.
Oh,
Yep.
yes, I'm back here.
Away from the outside.
Court does call the case, People versus Paul Wasson.
Morning, Your Honor. Raymond Cook for the people.
Your Honor, good morning again. Joe Simon on behalf of Mr. Watson to make his way to the podium. Paul, state your name when you get here.
Good morning, Your Honor.
Good morning. Your name, sir?
Paul Wassman.
For arraignment purposes, Your Honor, we'll waive formal reading of the complaint, stand mute.
And in a way from a reading standing mute, court will enter a not guilty plea. All right.
Regarding the pretrial, Your Honor, Mr. Cook and I are talking about possible dispositions. My client's doing some proactive things. We're asking to adjourn the pretrial to the next available day because I think we'll have it resolved by then.
Pretrial in this matter will be adjourned to
April 1st.
April 1st, 2026. 9 a.m. I get to see you again on April 1st. All right. Bond in this will be set in the amount of $5,000 personal with cognizance bond on lower standard conditions, including no assaultive behavior or possession of any weapons. So you understand that?
Yes, Your Honor.
You are also at this time not to possess or consume any alcohol, recreational marijuana, or any illegal drug. Will order also, is there any reason you need to have contact with a James Park?
They're strangers, Your Honor, no.
Although there's no contact with James Park. And the location is Costco.
The parking lot of Costco, Your Honor. I don't think there's I don't know if Mr. Cook's going to request it, but I don't think there's a need for a no go to or not be on premises.
Only to court's discretion.
Well, to your knowledge, were they both like customers there?
Yes.
Okay,
Yes,
then I'm gonna order no go. All right. All right, thank you.
Thank you, Your Honor. Get one of those conference rooms on and I'll be with you shortly. Sorry. Bet.
Okay. Court does call the cases of the people versus Angelo Andrews.
Your Honor, agreement cook for the people.
And good morning, Your Honor. Attorney Eric Chappell on behalf of Mr. Andrews.
Mr. Andrews, can you state your name, please?
Angelo Andrews.
All right, what are we doing on these?
Your Honor, I believe we've reached a resolution of matters where the defense will be admitting responsibility to an added count of impeding traffic on one added count on each case. That being Pact Code 2566B on acceptance with added counts of people who move to dismiss the original counts.
Is that a correct statement, counsel?
It is, Your Honor. Thank you very much.
Starting in case 1025. Mr. Andrews, do you admit responsibility to the fact that on July 9, 2025, at the location of southbound US 23 in Pittsfield Township, Washington County, State of Michigan, that you impeded traffic?
Yes.
Yes, Your Honor.
And sir, on the other matter, you admit responsibility to the fact that on that same date, well, how am I going to do? These are two citations that occurred at a one stop.
I believe so, yes.
So how do I get two impeding traffics? And
Your Honor, I would be fine with just one count of impeding traffic if defense counsel has no objection to making it one plea as opposed to two.
I do not, Your Honor, and I appreciate that very much. Thank you.
you would, but okay, then, and you're just going to dismiss out the other matter.
Yes, Your Honor.
So I'm going to dismiss then the case ending in 1026. Probably should have done it the other way. I will accept the defendant's admission to impeding traffic in the other matter. Fines and costs of $180. When can that be paid?
Your Honor, if we can have 14 days, we can get that taken care of.
Pay it by April 3rd.
Thank you, Your Honor. And thank you, Mr. Cook.
Thank you, folks.
Yep.
Court calls case People versus Derek Simpson. No relation.
Your Honor, ready for the people?
Judge, good seeing you again as always. Right after St. Patrick's Day, too. You know, I started to wear my green.
Hoping not to call your case.
Right, well, I started wearing my green suit today, Judge. I thought that might have been a little over the top. Right.
All right. Where are we?
Your Honor,
Client here?
Your Honor, the last time we were in court,
Mhm.
I've written Mr. Simpson. I've tried to call Mr. Simpson. I've had a text message from Mr. Simpson's mom who said she would forward information to him. I did receive one email from Mr. Simpson who informed me that he didn't have a phone, but when he did get a phone, he would contact me. And I said, Mr. Simpson, we need to speak immediately about this. So I do not know where Mr. Simpson is, Your Honor.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. 10% privilege. That warrant will issue immediately. Thank you.
Yeah.
Court calls case People versus Albert Wilson.
Morning, Your Honor, Raymond Cook for the people. I know I spoke with him earlier this. He might be one of the side messages like this.
Okay. All right. That was today.
I thought so. A very long walk. Judge.
Is it? Oh, was he way down the hallway?
No, he was in one of the side vestibules.
Oh, it's. Wow. Where?
Ready to talk a little bit?
Pardon?
Talk a little bit.
You can if you like.
Let's go in here and this thing go like totally honest. I thought it won't be sitting in front of Judge Judy.
Raymond Cook for the people.
Peter Winter on behalf of the defendant, Your Honor, in place of Mr. Amadeo. Good morning, Your Honor.
Morning. Your name, sir?
Albert George Wilson.
You don't have a problem with counsel stepping in.
I'm sorry,
You don't have a problem with counsel appearing?
No, it's all
All right, very good. All right, what are we doing?
Your Honor, I was in the process of speaking with Mr. Wilson. Are you willing to accept the plea or do you want me to ask?
Yes.
Okay, Your Honor, we discussed this matter with the prosecutor and Mr. Wilson tendered a plea of guilty today. And we are going to ask the court.
And charged?
Yes, Your Honor.
Okay.
And we're going to ask the court at sentencing to consider a community service in lieu of jail, Your Honor.
All right, but he understands I'm not making.
Yes, Your Honor.
Oh. May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Albert George Wilson.
Sir, it is his court's understanding that you're going to plead guilty to the charge of operating while intoxicated second offense. Is that correct? That's a misdemeanor punishable by up to a $1,000 fine, up to 1 year in jail. The court could also order community service and any rehabilitative programs the court deems necessary. Are you able to hear me, sir? Or did you?
Just barely. I'm sorry.
All right, no, it's okay. We've got some equipment that may assist you.
Hold on. You can.
All right.
Well, it is just about him a
Is
bit.
that better, sir?
Yeah, yes, it is.
It is? Okay. So I'll just start over. You're going to plead guilty to the charge of operating while intoxicated second offense. Is that correct?
Yes.
That's a misdemeanor punishable by up to 1 year incarceration. up to 1 year incarceration, up to a $1,000 fine plus court costs. Court could order community service or any rehabilitative programs the court deems necessary. Court could also order you to pay the cost of prosecution, plus cost of any emergency governmental services, and could immobilize your vehicle. You understand that?
Yes,
All right. And understanding all of that, sir, do you still wish to plead guilty
yes,
to that charge? How do you plead?
guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You had signed an advice of rights form previously. You recall doing that?
I'm sorry, I didn't understand what
You signed an advice of rights previously. You recall that?
no, not specifically.
All right. Back on the one that's returned to us, you signed it back on, well, you may not recall it, August 26th, 2025. Do you recall that form, sir?
I don't, but if you say so, I did.
Well, okay. But I have to make sure that you understand those rights on that form.
I've heard it's Mirandizing, right?
Pardon?
Mirandizing or whatever.
So here's what I'm going to do. I'm going to pass it. Let your counsel go through that advice of rights form. We'll give you another copy. I'll need you to sign that. I have to make sure that you understand all of the rights. Stand up.
Yeah.
Okay. I'll pass it briefly, and if they're ready, I'll get back up.
Thank you, Your Honor.
The hearing setback.
Thank you, Your Honor.
Thank you.
Back out into the.
Court does call the case, People versus Byron Blair.
Morning, Your Honor, Raymond Cook, people.
Good morning, Mayor. Police Court, Your Honor. Attorney Damian Caspi, number 85852, on behalf of Mr. Byron Blair. I forget the case number, but on the retail fraud case, and I know Attorney Brown is on the second matter, Your Honor, on the 0738 case, Your Honor.
Ron Brown appearing on behalf of 0991.
All right. Mr. Blair, can you state your name, please? Mr. Blair, you'll have to unmute. No, I see him moving. Mr. Blair? States. Oh, he could be. Oh, yeah, he is. You're right. He just dropped. All right. I'll pass it. We'll have to wait for him. Court calls the case of the People versus Ariana Banks.
Morning, Your Honor, Raymond Cook, people.
Ron Brown appearing on behalf of Ariana Banks, Your Honor. Ms. Banks, can you
hear me now? Yes, hold. All right. Ms. Banks is not answering. I'll pass that. I'll recall the Blair matter.
Sorry, Judge.
Mr. Blair, state
Hello?
All right. Hold on, Ms. Banks.
Yes, can you hear me now?
Okay.
Yes, I can. State your name, please.
Okay. Byron Blair.
Thank you. All right. What are we doing on his case?
Your Honor, a couple pieces of information I need. And Mr. Blair, if you can hear me, need a release form from Bear River Health so that we can communicate. And I need you to reach out to my office so that we can prepare and work on your mitigation letter. But right now, I'm being blocked from being able to communicate with you. So,
the thing is, I'm in transitional housing right now. I'm out of Bear River. I had all of that. Your office had all of my information. I got other cases that I'm going to court for, and like the public defender should have like all of my information, like my emails, my phone number, the release of information. They already faxed over.
Mr. Blair, I'm not with the. Let me pause you. I'm not with the public defender's office, and so I need you to communicate.
Oh.
Yes. So take down my information real quick. 313.
Why am I?
Okay, I need to get your
I'm sorry.
phone number.
I don't have a way to send my information. Oh. Just contact me at 313-915-0144.
What do I do?
Contact me at 313-915-0144. 313-915-0144.
915. 915 what?
0144.
0144. What's your name?
Yes, Attorney Cash.
Your name, sir?
Yes.
I'll call you. I might have to call you.
All right,
Okay.
please mute. Your Honor, if we may just have an adjournment so that.
Okay.
You want an adjournment too, or you hold the council?
I'll join in council.
All right.
Oh, yes.
What's my date after the? I will adjourn this matter to April 15, 2026, 9 a.m.
Thank you, Your Honor.
Bonds will continue. That's on both matters.
Thank you.
Thank you, Your Honor. Contact me today, Mr. Blair.
Yeah. All right. Clerk calls the case People versus Ariana Banks.
Morning again, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Ariana Banks.
Hi, Your Honor.
Hello, state your name, please.
Ariana Banks.
Thank you.
Your Honor, I'm requesting an adjournment. I need to talk to her about additional discovery.
April 1st, 2026, 9 a.m. Bond continued.
Thank you.
Thank you, Ms.
Thank
Banks.
you.
Clerk calls the case of People versus Taylor Chapman.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Taylor Chapman. Ms. Chapman, can you state your name? You have to unmute.
Taylor Chapman.
Thank you, ma'am.
Your Honor, I'm requesting a 30-day adjournment to get insurance, proof of insurance, prosecutor.
April 15, 2026, 9 a.m. Bond continued. Thank you. Court calls the case People versus Shamika Kurtendahl.
Raymond people.
Ron Brown appearing on behalf of Kurtendahl.
Good morning.
Good morning. Your name?
Shamika Kurtendahl. Can you guys see me?
No.
Okay, I'm trying to. Okay.
Well, there you go. We
Okay,
see
good
you now.
morning.
Great.
Your Honor, I'm requesting an adjournment, so hopefully she can get on track with a license. 30 days if possible.
April 15, 2026, 9 a.m.
Thank you.
Bond continued.
Thank you, Kurtendahl.
Thank you.
Court calls the case People versus Brandon Davis.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Brandon Davis.
I checked in.
Brandon Davis. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. Give a 10% privilege on that. That warrant will issue immediately. Court calls case of People versus Theodore Edwards.
David I. Goldstein.
Theodore Edwards.
We have a plea worked out in this matter, Your Honor. Mr. Cook is going to add a count of
Do I have
the advice of rights.
I have the advice of rights. Do I have a plea form?
Oh, there's no, sorry.
I'll pass it. Yeah, please. Court calls case of the People versus Michael Elkins.
Morning, Your Honor. Raymond people.
Good Judge. Court shall feature Assistant Public Defender on behalf of Mr. Elkins, who I hope is present.
Yes, Your Honor.
State your name.
Michael Elkins.
Thank you.
Thank
All right, what are we doing?
Thank you, Judge. Looks like Mr. Elkins' license was still suspended last week, and he's still trying to get that resolved. So adjourn or set it for final settlement conference, whatever the court's pleasure is, Your Honor.
April 15th, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls the case, People versus Sincere Godwin.
Your Honor, arraignment of the people.
Ron Brown appearing on behalf of Mr. Godwin.
Sincere Godwin. Oh, yeah. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $7,500. Give a 10% privilege. That warrant will issue immediately. Court calls case of the People versus Tony Gomez.
Your Honor, arraignment for the people.
Ron Brown appearing on behalf of Tony Gomez.
Tony Gomez.
Your Honor,
Yes.
we're in the process of having him evaluated for the Veterans Court in Dearborn. I've been in contact with him as of yesterday. I'm requesting an adjournment so that we can complete the process. My colleague did submit, I believe, an MOU in November. Ms. Perina.
I don't know, but we don't know where he is.
Your Honor, he is not in custody, but I've spoken to him all Friday, Monday, Tuesday.
Well, I'm going to issue a bench warrant from $7,500, 10%. That warrant will issue the 20th. Okay. Court calls case of People versus Joseph Hamby.
Your Honor, arraignment for the people.
Ron Brown appearing on behalf of Mr. Hamby, Your Honor.
State your name, sir.
Joseph Hamby.
What are we doing?
I'm requesting an adjournment, Your Honor. April 15th.
Why?
My information is the vehicle in question is not drivable. I'm trying to obtain verification of either transfer of title or scrap title so that there's no vehicle, proof we have no vehicle in the household.
April 15th, 9 a.m. Fine, continue. Court does call the case People versus Wilmer Hudson.
Your Honor, arraignment for the people.
Ron Brown appearing on behalf. State your name, sir.
Wilmer Hudson.
I have a plea form indicating that he's going to plead to attempted resisting and obstructing the 1-year offense upon a successful plea to, well, this form isn't filled out correct. Well, is this charged as an attempt?
Yes, it is. Yes, it is.
So he's pleading as charged to attempted resisting and obstructing. And then there's a prosecutor who will recommend no upfront jail. That's the court's full understanding.
That's correct, Your Honor.
Yes, sure.
That was one.
Raise your right hand. Do you solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
State your name, please.
Wilmer Hudson.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing. That's a misdemeanor punishable by up to 1 year incarceration, $1,000 fine plus court costs. You understand that?
Yes.
Still wish to plead guilty?
Yeah.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You've signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading, you're giving up those rights as well as all the rights on that form.
Yeah.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
May 5th, 2025, at the location of Ellsworth at Stone School Road, Pittsfield Township, Washtenaw County, State of Michigan. Did you come into contact with officers from Pittsfield Department of Public Safety?
Yes.
What happened?
Well,
Did they order you to pull over and exit your vehicle?
yes.
And did you refuse their lawful commands to pull over and exit your vehicle?
Yes.
All right.
And they were in uniform and you knew they were Pittsfield police officers?
Yes.
All right. Sir, I do have to advise you, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
All right. Counsel, you aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant's referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
9th at 12 noon.
April 29th, 2026, 12 noon.
I'd ask bond continue.
Bond continues. Court calls the case People versus Austin Ingram.
Your Honor, agreement for the people.
Pretty good. Court shall feast the assistant public defender on behalf of Mr. Austin Ingram.
During a plea.
Austin,
Hi,
state your name. Say your name, please.
Austin Ingram.
Thank you, Judge. I did speak to Mr. Ingram and father yesterday. I believe they're requesting this matter be set for final settlement conference and jury trial, Your Honor.
Jury final settlement conference in this matter, April 10th, 2026, 9 a.m. Jury selection, if necessary, April 13th, 2026 at 8:30. Both of those proceedings are in person.
Thank you, Judge.
Bond with its conditions will continue. Thank you.
Thank you, Judge.
Court does call the case People versus Devon Foster.
Raymond Cook for the people.
Yes.
The Judge, Court shall feast the assistant public defender, appearing on behalf of Mr. Javon Foster. Please state your name for the record.
Devon Foster.
Thank you, Judge. It looks like he was recently arraigned. I believe we'll be asking for an adjournment to speak to Mr. Foster and see what possible resolutions there are.
During the matter, April 1st, 2026, 9 a.m. Bond continues.
Thank you, Judge. You got a comment?
Good. Court recalls the case of the People versus Theodore Edwards.
One, Your Honor, Raymond Cook for the people.
Doug Goldstein is bringing on behalf of the defendant.
Theodore Edwards.
Now, Your Honor, we have reached a plea agreement. He's going to plead guilty to an added count of retail fraud third and make restitution. In exchange, the people are dismissing the original charge.
So, he's agreeing, the defendant's agreeing that he'll pay restitution.
Yes, Your Honor.
Your Honor, for what it's worth, I don't believe there will be any restitution owed on this case. My understanding is
Okay, but if there is any, obviously the agreement is he will pay.
Okay. And I just added that to the form. He agrees to pay restitution if any. And that's the court's full understanding of the agreement. Is that correct?
Correct, Your Honor.
Kevin sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Theodore Edwards. Sir, it is this court's understanding that you are going to be pleading guilty to the charge retail fraud third degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
That wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct?
Correct.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. Understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes,
You understand you're giving up your right to appeal of right.
correct.
Are you on probation or parole?
Misdemeanor.
He wasn't at the time of this offense, Your Honor. He is now.
Has anybody promised you anything other than what's
No,
stated here today on the record to get you to plead? Anybody threaten you or coerce you?
no, Your Honor.
You're doing this voluntarily
Absolutely.
of your own free will
Yes, sir.
and because you believe that you're indeed guilty of this offense?
Correct.
On the date of July 21st, 2025, at the location of 3749 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. What did you do at the Target store that makes you guilty?
Had some items that wasn't purchased.
Okay, so you went into the store,
Yes,
picked up some items and tried to walk out without paying for them?
yes, sir.
All right. And the store was open to the public at the time?
Excuse me?
The store was open to the public at
Correct.
You didn't have anybody's permission to take that property, did you?
No, sir.
And the property that you took was property that Target had offered for sale?
Absolutely.
All right. Sir, if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court has to advise you that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Correct.
Counsel, aware of any other promises, threats, or other inducements which have led to this plea?
Some people.
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant's referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
April 29th at 12 noon.
April 29th, 2006.
29th, Your Honor, that's fine.
Yes, 12 noon.
9, I'm sorry,
Bond will continue.
9 o'clock,
Noon.
noon.
All right, sir, make sure to stop down at my probation department about halfway down the hallway.
Okay.
All right, on the left-hand side.
All right.
May I approach for a moment, Your Honor?
Man. I got it. Court does call the case of fixing housing 401k versus Erica and Aaron Ward in regards to the bench warrant issue. This is a matter involving Donna Tope. Ms. Tope. Yes.
Good.
State your name.
Donna Tope, I'm hearing on behalf of myself.
Ms. Tope, I had issued a bench warrant for your arrest. For failure you to appear at a show cause hearing, which I know that you had notice of. You filed a motion in this case to remove and expunge the court's order for contempt. And the warrant for your arrest. That is your motion before the court today.
Yes.
Go ahead.
So I would like to put this on the record for my own purposes and also for YouTube. The YouTube that was recorded when you issued this bench warrant has been used against me in my professional capacity and for other cases. And therefore, I would like to have this on the record.
Have what on the record?
What I'm going to tell you now in my defense.
Go ahead.
Okay. It's my motion. The following enumerated facts support my motion to remove and expunge from every record, including the YouTube video, A, your order for contempt, your warrant issued for my arrest, and your order to hold me under arrest on $10,000 cash bail. I received the judge's final docket for hearings set for Tuesday, February 3rd, 2026 at my email address on Monday, February 2nd from Ms. Weedling. I opened the email the morning of Tuesday, February 3rd, because I am a party in a completely different case before this court, and I looked for something on that case on the docket. To my surprise, the docket for 2 p.m. that very afternoon had me listed for a show cause hearing on a case for which I am neither a party nor an attorney. Not having had any notice of appearance for this hearing, I was not able to get to the court in time. So I sent Ms. Weedling the email, which I attached on my motion as Exhibit A, explaining that to the court. I receive all of my business mail at Post Office Box 1283 in Ann Arbor, Michigan, 48106. I check my mailbox weekdays after 5 p.m. On Thursday, February 5th, 2 days after the unnoticed show cause hearing on the court's February 3rd docket, I sent Ms. Weedling the email and photos provided at Exhibit B. The email describes what I received that morning, Thursday, February 5th, 2026, in my post office box, 2 days after the hearing was held. The photos included with my email to the court are of a motion affidavit in order to show cause signed by Judge Simpson, along with the postmarked envelope they were mailed in. Exhibit C is hard copies of those legal papers and the envelope. The motion at number 2, page 1 states, I am being held by the judge in contempt for filing a pleading without my client's knowledge, nor being the attorney of record. At number 3 on page 1, Judge Simpson requests an order to show cause why I should not be found in civil contempt of court. Can you attach it for me? Thank you. At item 5, page 2, I am ordered to appear before the court on February 3rd at 2 p.m. At 7 on page 2 of the order to show cause, it states that a copy of this order must be served by mail on the person ordered to appear, which is me, at least 14 days before the hearing, which had been set for a hearing on the docket for February 3rd at 2 p.m. The judge's signature is dated January 20th. The envelope is postmarked January 28th. The date the post office mailed it, which is only 6 days before the hearing date of February 3rd, which is not the quote, service by mail within 14 days required by the judge's signed order. I received the order at my address on February 5th, 2 days after the hearing was held, and only 8 days after it was mailed, which is 6 days shy of the required 14-day notice by mail. The facts are that I was not properly served nor properly noticed of the hearing at which Judge Simpson found me in contempt for not appearing. The further facts are that in finding me in contempt for not appearing, Judge Simpson issued a warrant for my arrest and demanded an excessively punitive cash bail of $10,000, or so I was told by a person who was in the courtroom when Judge Simpson put his order for my arrest on the record. Based on what I have provided, the judge's motion and order in the mailing envelope, I am asking for the following relief from Judge Simpson. Please retract, remove, and/or expunge all records of the order for contempt, the bench warrant, and cash bail issued by the judge so that there is no evidence out on the web that the judge issued the order, the warrant, and the excessively punitive bail. I include court records, transcript records, and the YouTube video of the judge's orders that another attorney alerted me to in cases that I am appearing in 3 other circuit courts, and reissue with proper notice to me the show cause hearing the judge wishes to impose upon me. I am perfectly happy and willing to appear at a show cause hearing if I have proper notice. I did not.
This is your proper notice. You had notice. I will stand on the record that I made that day that you had notice of that hearing and that you failed to appear.
And
my staff indicated that. You can argue with me all you want, Ms. Tope. What I will do, though, because you have part of the reason that the bond is set in the amount that it was, is because you had basically been removed from the case, this case. You had filed a pleading, you signed it. Your former client had no knowledge of it.
That is not,
was delayed.
not correct.
You want to know what? Do not interrupt me, because then there's going to be a whole other problem. Your client stated on the record they did not have no knowledge of it. Defense counsel or plaintiff's counsel had to respond. The amount of the bond is the amount of billings that the plaintiff had incurred based upon you filing pleadings when you weren't supposed to and the delay that you caused. It was set in that amount. What I will do is I will cancel the bench warrant. I will reset your show cause hearing. So here's your notice for April 14th, 2026, 9 a.m. Thank you. Have all your witnesses, and if you wish to be represented by counsel, you need to have counsel present at that proceeding.
Thank you.
Are you understood? Am I understood?
Clearly.
Thank you. Well, that was fun. Court does call the case of the people versus Albert Wilson.
And your agreement goes to the people.
Your order on behalf of the defendant, John. Appreciate the brief adjournment. Court permitted to discuss this with Wilson. He has read the advice form that was tendered to him. He's re-signed it. It's put your ears up. Yeah. Okay, good.
You hear me?
Yes.
All right.
And he has signed it, so I'm sure that he's familiar with it, Your Honor.
All right.
We've also
Are you signed and gone through that advice of rights form, sir?
Yes, I did.
Any questions regarding any of those rights?
No.
All right, look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, he said that.
All right. You understand that you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, signed.
Has anybody promised you anything other than what's been stated here today?
File.
Which is nothing. It's you to plead to this case.
No.
Anybody threatened you or coerced?
No.
You're doing this voluntarily and of your own free will?
Yes, I am.
Your Honor, I might amend that if I might. We have an agreement with the prosecutor that the prosecutor is going to recommend community service. And if the court doesn't give him community service at the time, then he has the right to withdraw. That's the only.
I am not. You guys can agree to. I am not agreeing to.
I understand that, Your Honor.
And to make it clear, the plea form that I believe was handed over says that the people are recommending the community service instead of jail. I understand that the court is not bound by that, but that's what the people will be recommending.
Yes, Your Honor. The other thing we would request is in discussions with the prosecutor, Mr. Wilson has had, as I think the court is aware, has had some difficulty, justifiably or not, with the testing required by the court. And the prosecution suggested that he wear a scram, and Mr. Wilson is okay with that. If the court,
I don't know
will accept that.
with that now. I'm in the middle of a plea. I don't even have a plea.
I just wanted to make that clear to you, Your Honor.
Are you on probation or parole?
Oh.
Has anybody promised you anything other than what's been stated here today, which is really, as I said, nothing to get you to plead?
No,
Has anybody threatened you or coerced you in any way?
no.
Doing this voluntarily and of your own free will?
Right.
And also because you believe that you're guilty of this offense?
Yes.
September 7th, 2024, at the location of 5915 West Michigan Avenue, Pittsfield Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What did you have and how much?
Well, it's vodka, but I don't exactly know.
All right, but you were drinking vodka before you drove? All right. Were you stopped by the police or was there an accident?
Well, I wasn't neither, actually. I was stopped in a parking lot when I walked out of a building.
Okay, so you drove, you would admit.
Pre-sentence investigation.
Yes, Your Honor.
Yes, Your Honor. Ms. Nicholson, anything on behalf of the state?
Your Honor, we are not requesting restitution at this time. We will defer to probation's recommendations. It's our understanding that Mr. Simmons has 84 days of jail time credit.
Anything from probation?
Nothing further, Your Honor.
Mr. Brenner?
Your Honor, we are in agreement with the 84-day jail time credit figure. I know the court's aware he also served a sentence out of another court, a 29-day sentence in that interim. He's been locked up since before Thanksgiving. I know he took responsibility. He's been forthcoming about his issues. This was obviously a stupid decision. I think he's highly motivated to get out in the community, to be a productive member of society, to be a parent, and again, do what he needs to do to stay out of jails and courtrooms moving forward. I know that drugs were involved in this incident, and my hope is that he's able to do what he needs to do to stay out of this courtroom moving forward, Your Honor.
Thank you. Mr. Simmons, anything you want to say?
I'm sorry for what I did. It won't happen again.
How many times have you said that to a judge?
In my past, I've said it more than once.
Yeah. All right. Court's considered the statements made here today, the purposes and principles of sentencing, the relevant seriousness and recidivism factors. Mr. Simmons, at your age, you need to stop breaking the law. You have a horrible record. You deny that you have a drug problem, but you clearly do, and you steal from people. So I don't understand what it's going to take, but I will give you an opportunity and find today that you're amenable to community control. So I'm going to place you into community control for a period of 3 years. You will be subject to the supervision of the Warren County Probation Department. I am ordering you to refrain from the use of any drugs, alcohol, or marijuana. Do you understand?
Yes, Your Honor.
You're ordered to successfully complete the theft class. You're ordered to successfully complete substance use disorder treatment. You're ordered to obtain and maintain full-time verifiable employment. I will release you today on electronically monitored house arrest, and as there is no restitution request, the court will also find that you're indigent for the purpose of any fines, costs, or other financial sanctions. You have 84 days jail time credit. You're also subject to a discretionary period of post-release control, which means if the court sends you to prison at any point on this case, when you are released, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, the adult parole authority can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. You do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, including an attorney, that can all be provided to you at no cost. Ms. Nicholson, is there anything else?
Do you want any length of time on the monitor or at probation's discretion?
PO discretion. Mr. Brenner, is there anything else?
No, Your Honor.
All right, Mr. Simmons, let's get this right. That's all.
You need anything, give me a call back.
admit that you drove into a parking lot?
No, I didn't go into a parking lot. I parked on the side of the road. The Michigan Avenue was torn up at the time and they were laying down asphalt and to get into the liquor store.
Pardon?
Get into the liquor store, I would have had to drive over a big bump, like the asphalt, but it was maybe a foot, and I thought it might hurt my car. So I parked on the side of the road.
Okay, so you drove to the side of the road, you parked on the side of the road.
Yeah.
Went to the store.
Yes.
You came back out.
Yes.
Okay, but you admit that where your vehicle was parked, you drove it to that location.
Yes.
All right. Did the police arrive? Or they were out there when you came out?
An officer walked up to me when I came out of the building.
When you came out of the store?
Yeah, and he put handcuffs on me, so on.
Okay, he didn't put handcuffs on you right away?
He did.
Did he say why he was doing that?
No, he didn't arrest me.
What?
Well, as far as verbally, no, he didn't arrest me. I don't recall that at all. He took the package I had in my hand first, and he put handcuffs on me. And a little later, he asked if I take a breathalyzer, and I said no. And yeah, that's what happened.
Okay. Are you challenging the right of the police to stop you and arrest you in this instance?
Well,
No,
no,
thank you.
Well, what?
You're not challenged.
I do not challenge.
Okay. And so you were ultimately arrested.
Yeah. Yes, Your Honor. Phew.
Were you taken to the hospital for a blood draw?
Yes.
What were the results of that blood draw?
I don't know. Suppose you have the record.
What did it be? 0.124?
I don't know.
Okay, if I told you it was 0.124, would you have any reason to dispute that?
No.
All right. Sir, were you previously convicted on or about February 15, 2022 in the 14A4 District Court, that being Saline, on the charge of operating while intoxicated?
Yes.
All right. And sir, I just so that our record is clear, when you parked that vehicle on the side of Michigan Avenue,
yes,
correct?
Yes.
And you had drank vodka prior to arriving at the place where you parked that vehicle?
Yes.
All right. Sir, if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
I understand, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
April 29th at 12 noon.
April 29th, 2026, 12 noon. As to bond in this case, he wishes to be switched to, he's currently on a sober link, right?
Yes, Your Honor.
And he wishes to be switched to a scram?
Yes, please.
I will switch the defendant. We'll prepare an order switching him to a scram. Do you have the sober link with you?
Yes.
All right, you can go over there. We'll send the order over and do that. Anything else on this?
No, thank you, Your Honor.
Oh, pardon?
That's it for 9 a.m.
That's it for 9 a.m. All right, then I'm gonna take a brief break, come back. We'll get set up for the next block and we'll see. Courts and Reese. All rise.
May be seated.
confinement. That confinement could be probated and you would, a regular probation, which is different from deferred probation. In deferred, you're not found guilty, but you could be placed on regular probation and then probated. That could be probated up to 10 years in length. So those are three options. Do you understand?
Yes.
And what we'll do is have a sentence report prepared, come back in about 4 weeks and take up sentencing at that time after everybody analyzes the options. Okay. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement of a cap of 5 years in prison, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, ma'am? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will. And because you are guilty, help me. Thank you. Right, come forward. Oh, there you go. I want to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with your attorney or the contents true and correct? Yes, State's Exhibit 1 tendered into evidence.
No, good.
Without objection admitted. This states, among other things, that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any else included offenses you with giving up your.
You have the right to be represented by a lawyer in these proceedings. If you can't afford a lawyer, I will appoint one for you. Do you want to be represented by a lawyer?
Yes, sir.
Are you going to hire a lawyer or do you want one appointed?
Can you appoint one, please?
All right, Ms. Kuroko is going to give you an affidavit that tells me in writing that you don't have the funds to hire a lawyer and want one appointed for you.
Chloe.
I do find that you are indigent for the purposes of hiring a lawyer in the case, and I'm going to appoint Ms. Kirby to represent you. You have her contact information there. We're also going to send her an email today that lets her know that she's been appointed. And I'm going to set this for, I don't want to set it for a final hearing. Here's my problem in this case, Ms. Peoples. I don't know if you're going to be able to help me with this problem or if you're just going to make it worse. Officer Fisher and I have a bit of a disagreement in this case about how it should go forward. I think if any of these things are true, you've been on probation with me for almost 2 years now, a year and a half or so, and you haven't done anything. And I think that I should just go ahead and impose the standard sentence that I impose for people who bring drugs into the prison, which is 90 days in jail. Officer Fisher tells me that she thinks that you can get this together in the community and that you can give me some reason not to put you in jail. I don't think that's true because you've had a long time to do this. You don't have a job. You haven't done the evaluations that we've asked you to. You didn't show up to court last time. You don't come to your office visits and you have a bunch of weed at your house when they do a home visit. Did we pass our drug test today?
Yes, sir.
Well, that's something then. Did we even pay the $35 in reimbursements? Is that still owed? Please tell me that's not still owed.
Yeah, I believe she paid it, Your Honor. I paid it.
Here's the thing, Ms. Peoples. You seem like a decent lady to me, and these things that are violations of your probation, if you weren't on probation with me, they wouldn't even probably be violations of the law. But I have to figure out what to do in this case because you brought drugs into a prison in my jurisdiction, and I don't take that lightly. But you do not seem to be doing anything that is helping yourself to convince me why I shouldn't put you in jail. I appointed you a lawyer, so I don't want you to talk today. I know that's not really fair to you, but I'm not going to do anything to you today. I mean, you're leaving today regardless, so I'm not going to do that today. But here's what I would like to happen. I'm going to set this for a final hearing in a couple of weeks with Ms. Kirby's schedule. I don't anticipate that that's going to be a final hearing because I don't think that you can get it together in the next 2 weeks to give me good enough reason why I should not put you in jail. So I'm thinking after that I'm going to set this out for about 60 days. And what I would really like is for you to sit down with Officer Fisher and have a heart-to-heart talk with her about whether you're going to do anything to demonstrate to me in the next 2 months why I shouldn't put you in jail. And if you guys can put a plan together and then you can execute that plan when we come back here in 2 months, then I just want to terminate you from supervision and be done with you. So if you can do those things to show me why I shouldn't do that, then I would be happy to just dismiss this violation or whatever and get you off probation. If you can't do those things, then you just need to go to jail and be done with us. Do you understand all of this?
Yes, sir.
All right. I do find there is probable cause to believe you have violated the terms of your supervision, and I'm going to appoint Ms. Kirby to represent you. We'll see you back here for a hearing in 2 weeks, but Officer Fisher will have some things that she wants you to do between now and the time. The idea is for us to come back in maybe mid-May and for you to have something going by then. I do think Officer Fisher, if I'm not mistaken, we just got an email on the shred day that they need volunteers for community service on the shred day. That might be a good thing for Ms. Peoples to participate in.
Mm-hmm.
That at least is a little bit of, shall we say, contribution to the community in Warren County, something like that. Maybe talk to her about that or something else. I just want to figure something out. Okay, Mr. Harris, anything from the state?
No, Your Honor, thank you.
All right, I'll see you in a couple of weeks, Ms. Peoples.
Yes, sir.
The rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, and totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
States Exhibit 1 is part of the records for all purposes, and we're going to reset this matter. We'll come back on
April 29th.
April 29th of this year, and a pre-sentence report will be prepared. Parties will have an opportunity to review it, and then each side will be able to make what they believe is their arguments for the disposition. Please get a resetting and work with the probation officer here. They're going to start the probation pre-sentence report today. Okay, thank you.
Oh, here.
No, I'm sorry. Ma'am, you need to get.
Yes, direction. Just not.
He gets a lot of people in trouble.
Give you this.
What?
And then now you go. Thank you.
Thank you, ma'am. What do you have?
The other one's emotional remote. She's just saying, so is it true? So we get it up there, receipt you.
Is it Amanda?
Yes.
Is that you, ma'am? Amanda Nolan?
Okay, just something to add on. I don't think that we have a probation officer here today. She goes added on the last minute. And probation is on the way. Oh,
Does she need to go to you in any way?
no.
All right, we now call cause number 19-32306, the state of Texas versus Amanda Michelle Nolan. Is that you, ma'am?
Yes, sir.
Present. And Mr. Kimler, here's your attorney,
Yes, sir.
and the state's attorney is present. Does the defendant waive a formal reading of this first amended motion to revoke probation? Can we proceed in summary?
She does. Really nice.
And raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lawyer.
I think she's already entered
See this fact.
the allegations that precede the first amendment, Your Honor, so I'm not certain.
Well, we got to work off the most recent thing.
Since she's prepared to plead new allegations in the NCRP.
Yeah, in August, she pleaded true to 1, 4, and 6 of the original,
Right.
which I guess,
This is from 2019. It's a state jail, so I'm sure she's going to continue at some point or extended at some point.
what did we do back in August?
I wasn't.
I'm just going by the notes that
This
were.
August,
Mhm.
and I don't know.
Defendant was HIA on August the 11th. Admin hearing 10/23. File. she did the first one.
Well, we got a first amended motion and that's new. Yeah. In summary, this motion alleges first amended motion to revoke probation filed on December 18th of 2025. It states that on November 18th, 2024, in this court, you were sentenced to 2 years in the state jail, and that was suspended, and you were placed on probation for 5 years for theft. State jail felony of theft. Is that true? Allegation 1 states you failed to report to the Jefferson. First amendment. Let's go to the first amended part. First amended 7 states you reported as to, I'm going to skip that one, okay? Number 9, you provided a urine sample on or about October 21st, 2025, which showed the presence of phencyclidine, PCP, which was a violation of condition 10 of your probation order. Is that true?
That is true, but I got am I able to talk?
Not yet. It's true.
Is it true or not?
That is true.
But you can, and
That was in a cup, and I went to Elizabeth Green, my primary care physician, not my doctor, not my cancer doctor, and I got a laboratory test in my medication list. And I brought that back to Miss Asia.
I don't know what you're trying to say.
Like a negative UA from the lab.
She's
Plus diagnostic.
She's on quite a bit of a cocktail of medications for cancer.
Did you test positive and
Yes.
did you have PCP in your system? Yes or no?
According to the cup, yes, sir.
I think she's pleading true that she tested positive for PCP, but she didn't have PCP in her system. If that makes
I did
sense.
not.
So I don't have.
Well, that's. Oh,
She did test positive for PCP. That's true.
okay. Here's what you had to do. Here's the probation order. Allegation, condition 10. This is what it says in that you violated. 10, which you signed and the court signed the order that you had to follow. 10, do not use or possess any drugs. Use of, possession of, and prescriptions for any and all medications must be immediately disclosed to your probation officers. Did you violate condition 10 or not?
Yes, sir.
Sir, didn't.
Yes, sir. I guess. I don't know.
Well, did you use PCP?
No, I did not.
Okay.
All right. Well, we have a test that shows a positive.
Yes, just from probation. She's saying she didn't, but we have a test. So.
Thought we were disposing of this today, where this is going to be contested.
Well, she's not contesting, she tested positive. Oh, that's true.
That's not the test. It says you provided a urine sample that showed the presence of phencyclidine, and the test, well, that's what it says. But the probation order is do not use or possess any drug illegally. And that's the violation, not testing positive. That's a violation that's indicative of the violation. But
I know she's indicated to me she's She has kidney cancer and she's actually scheduled for surgery.
Well, phencyclidine
I don't know.
is unique and you get it. They're not going to, they generally do not prescribe
No,
from as lawful medication. It's out there, but it's not
Various cancer drugs. I have to look at the test. I don't know.
well, we stand by the test. So
If she's prepared to plead through the rest of the allegations.
11 states you failed to report to the Jefferson County Probation Office on or about December 3rd, 2025 and December 4th, 2025 in violation of condition 4 of your probation order, which states you must report regularly.
yes, sir.
Is that true?
Yes, sir.
True.
True.
No, I said, is that true? And she said, yes. Good enough. You failed to submit to an alcohol and or drug screening on or about December 3rd, 2025 and December 4th, 2025, which was at the direction of the probation office. And she didn't come in. Is that true?
Yes, sir.
Why?
I was sick. That's before I stopped going back, right? I mean, that's after I stopped going back. That's when I found out my cancer was back.
Did you know that was?
I knew she had cancer, but in the findings, that's not listed as the reason for the
What was
defendant parent. Says that the UA was not able to be, the individual did not make the appointment as instructed. There's no reason listed. Mhm.
Number 13 states you failed to provide verification of successfully completed moral recognition therapy, MRT, as directed by the probation office. Is that true?
I started it.
You didn't finish.
No, I didn't.
So that's true.
Mhm.
So is that true?
Yes, sir.
And number 7, up at the beginning states, you reported as directed, but failed to obey the rules and regulations of the probation office on or about October 21st, 2025 by leaving the office without permission after submitting a positive drug test in violation of condition 4 of your probation order, which states report as directed and obey all rules and regulations of the probation office. That states you left the office after submitting a drug test that proved to be positive and you left without completing. Here's what we're going to do. There's too much hedging going on.
Yeah,
I'm setting this for you. And we'll let the state have a chance to make its presentation. And let's do this as soon as possible. Okay. Within 2 weeks.
She's got a.
I have kidney.
I'm sorry, but we got to do due process in the right way, but we're going to work with your medical condition, but this doesn't get it.
Yes,
You've hedged on every answer and we'll just give the state an opportunity to be heard and then the court will make its decision. That's what we'll do. But that's what happens when, I thought y'all had figured this out.
Well, she's gonna have a plea true.
Every true was a conditional. No, it's not. She's under oath and she made conditional dispositions. Now she's going to change her mind because I'm setting it for a hearing. No, I'm just going to set it for a hearing. Okay, we got to do it the right way. That looks bad on paper. Okay, if we're going to reset it, well then I'm going to plead true now. Well, she already had her chance, and that's under oath, and she did not acknowledge forthright, and she has a right not to. And it's the state's burden. We'll set it for a hearing. Set it for a hearing as soon as possible.
She's scheduled for surgery the 31st. I don't know if the jail's going to transfer.
We'll try to get it.
It's the jail
as soon as we
They
can.
haven't brought me at all. My kid's dad, he sent the court clerk. I don't know.
We'll set it as soon as possible. That's all we can do. I got other things. We'll set it. Thank you. Y'all, that's what happens is everybody goes over those things with the client and then they know that it's not a big surprise.
She said the transform. Just before the second.
Jason, you ready?
Yes, sir.
Come on up. Victor Martinez?
Yes, sir.
Thank you. 25 CR 301 is called Victor Martinez Jr. You agree with Mr. Nix, your attorney and the state's attorney? Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
He does, John.
In summary, this indictment alleges that on or about November 8th, 2024 in Jefferson County, Texas, you committed the state jail felony of intentionally and knowingly operating a vehicle that was involved in an accident resulting in injury to others, and that you did then and thereafter, knowing the accident had occurred, intentionally and knowingly left the scene of the accident without giving your name, address, registration number of the vehicle you were driving, or the name of your motor vehicle liability insured to any person, and without rendering reasonable assistance to the other party when it was apparent that the other party was in need of medical treatment and the accident resulted in serious bodily injury to the other person. Do you understand what you're charged with?
Yes.
This is a state jail felony. And that means it carries with it, if convicted, confinement in a state jail for any term of not less than 180 days or more than 2 years. Additionally, you may be assessed a fine not to exceed $10,000. Do you understand? Speak up.
Yes, sir.
The agreement's been reached where you would be sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years. Restitution is ordered in the amount of $2,932.73 to, I guess, the complainant here.
Yes, sir.
And there will be other terms and conditions of probation which are normal and customary for this type of offense. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's submitted. Among other things, this states you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. You've discussed this with you or with your attorney. And you were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses. And totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God. Correct?
Yes.
So speak up. States Exhibit 1 made a part of the record for all purposes.
Joshua James Kaladzai. Come on up here, sir. 25D236628. Your name?
Joshua Kaladzai.
You're being show coached.
Yeah, I just got confused about the whole process. I had spoke with the prosecutor via Zoom call back at the end of November, and he said something about being able to do a pro.
I adjourned it to December 2nd and you were supposed to be here then and you didn't show up.
Okay, I didn't even notice that. I didn't get that told. I don't even know if I got that notification.
Well, you came in front of me that day, right?
No, I didn't.
Oh.
And like I reached out to try to understand what happened after the second there. Nobody contacted me back. I tried via email and some phone calls, and I have the emails from the prosecutor on my phone.
You weren't very diligent, were you? You didn't think I adjourned it until 29, did you? 2029. I mean, come on. I adjourned it a week
Okay,
and then you didn't show up.
I wasn't aware of that, sorry.
Well, did you move?
Now, should be 7200 in drive.
7200 Richmond Drive.
Yeah,
We told you to appear in person. We sent the notice out on the 25th of November. We sent it to your address.
okay.
I told you to appear December 2nd at 9:15, and then you didn't. And I entered the default, and then we sent you notices and you didn't pay, and then we initiated a show cause.
I didn't realize that I needed to show, sorry.
What'd you think was gonna happen?
I was trying to contact to understand what.
This is March.
Yes,
We don't take this long to deal with civil infractions.
yes, sir.
If I did that, we'd have to build a 15,000 square foot addition on here to store all the files.
Yes.
You owe 200 and $13. Do you have that?
Yes.
And then you have a $35 warrant fee. You made a mess out of it. What do you do for a living?
I work for FedEx. That's one of the busiest times of our year. This is in December, unfortunately.
We're all busy. I'll make it 200 and I'll waive the balance for you.
Okay.
You pay 200 now, balance waived, okay?
Okay.
Be more responsible, will you? How old are you?
Almost 40, yeah.
40?
Yeah.
What are those? Nicole Ann Schultz, 26W841617A. B.
We're down.
I'll be with you momentarily, Mr. Sparrow.
Oh.
Your name?
Nicole,
You're charged with driving on a suspended. You have the right to an attorney. If you want one, I will appoint you one. Would you like one?
No, I don't.
All right. I'm gonna go ahead and arraign you then and send you to the prosecutor.
Okay.
On February 20th, 26, it is alleged that you did operate a motor vehicle with suspended license on Goodith and West in Woodhaven. That is a misdemeanor. That happened at 11:42 in the morning on that date in Woodhaven, and that is a misdemeanor punishable by up to 500 fines, 93 days jail. Costs of all those are 2 points. Do you understand that? Did you sign, read, and understand an advice or rights form here today?
My hand was shattered and it's my dominant hand, so I can't write.
Geez, I'm sorry.
That's part of the reason why I got pulled over. I was on the way to the hospital to get my
Slow down, slow down.
I was on the way.
Slow down. I just want to know right now, and I'm sorry you're going through that. Did you read this form?
Yes, I did.
Did you understand all the rights on this form?
Yes.
If you plead guilty, you're going to be giving up all these rights, and we're not going to have a trial of any kind. Do you understand that? All right. Now, do you still wish to waive your right to a lawyer?
I can get a lawyer. Yeah. I wanted, can I talk to one? You guys
I
have.
thought you said you waived your right to a lawyer when I first asked you. Did you do that or not?
Yes, I did.
Well, here's what I'm going to do. I'll enter a not guilty plea. I'll give you a $500 personal bond. Here are your bond conditions. You cannot leave the state without the consent of the court, violate a law. You must appear in court as directed. I'll just appoint you a lawyer now. John Dillon, a lawyer. We'll send you to the we'll send the lawyer to the prosecutor. You have a defective equipment civil infraction charge as well, by the way.
What's that? I'm sorry, I don't know what.
Defective equipment. They said you didn't have a brake light working.
Oh, yes, there was no break.
Okay, so go talk to the lawyer. The lawyer will go talk to the prosecutor for you, and then you'll come back in front of me. Okay?
Okay, thank you.
Good luck. Abakar Hussein. 26.841640. Who is Mr. Hussein? Is anybody, do you have Hussein?
Yes,
Come on up here.
just, I thought everyone knew what a PD pad.
What do you mean? Somebody didn't know?
Well, yeah, is that good? I'm like, yeah, it's good.
All right, your appearance?
All you have is Mr. Hussein.
Do I have an appearance? Yes, I do. You're authorized to enter this plea. You're gonna plead to impeding, true? To that charge, responsible or not responsible?
Responsible.
Please accept it. It's a commercial vehicle, 180. I'll give them until the 25th to pay, okay?
Oh, sounds great.
Have a great day. Pardon?
Did you say 180?
180. Right, thanks.
Yeah.
Cruz. Dustin Antonio Cruz. 2-6-W-841491. Your name?
Dustin, Dustin Bruce.
You're charged with criminal responsibility violation. You have the right to an attorney. Would you like an attorney? Okay, we'll give you an attorney. You need to go out in the hall. We'll set you up. Ma'am, you need to go out in the hall too.
I said sit down right here. I'm sorry.
That's okay. And then after you speak to the lawyer will go talk to the prosecutor for you, okay?
Yep, thank you.
All right, no problem. All right. All right, Reginald Steve Wilson Jr., 25D149900A. All right, good morning.
Good morning, Your Honor. Hi, good, sir.
Your appearance?
For the record, James Sparrow, here on behalf of Mr. Wilson. Time to be accepted.
Sir, your name?
Reginald Steve Wilson Jr.
He immobilized his vehicle, correct?
Yes, he
He's
did.
on the sober link, goes, correct?
Yes, he is.
He wants to get into sobriety court, is that correct?
Yes.
Is that what you want to do?
Yes, sir.
You sure you're up for this?
Yes, sir.
You know it's not easy, right?
Yes, sir.
You're gonna be there today, right?
Yes, sir.
All right,
I'll be here at 3 p.m. sharp.
all right, good enough. Did you have a chance to review the report with him, and are there any material additions, corrections, or deletions?
I have, Your Honor. It is factually accurate.
Anything that you would like to say on his behalf?
Your Honor, I represented Mr. Wilson on the prior offense also. I've spoke with him in detail about this. I told him when sobriety court was an option that you would be very candid, and at times you almost, tell defendants that how difficult it is, and almost tell them like, hey, don't do this if you're not gonna take it serious. He knows exactly what's expected of him. I've followed up with clients over the years about the program. I've told him, some of the success stories and some of the how it's changed some of my clients' lives. The resources and the structure of the program are fantastic. He knows what's expected of him. This isn't an opportunity for us to tell you what he's going to do. It's for him to show you what he's going to do. And I hope he does really well with this and handles this with an open mind, which he is.
Anything you would like to say, sir?
Not really, Your Honor. Just ready to get this started and do what I gotta do.
All right, because this is not good. You had two within about 18 months. This is a 199, so we got to get this under, we got to get it under control, okay?
Yep.
All right, 2 years probation. I'll be glad to take you. But remember, this is a marathon. This is not a sprint. So I'm sure you're not finding things easy right now. As time goes on, you'll find it a little bit easier. But nobody has ever heard me say that this is an easy program to get through. But in the end, you are going to have changed your life dramatically, and it's going to be for the better. So I'm sorry, 2 years probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, place of employment, or home telephone number, you must notify probation. You have to report as direct. You're to comply with all agreements, guidelines, and requirements as set forth in the Sobriety Court Participant Handbook. You're not to purchase, possess, or consume alcohol. You're not to purchase, possess, or consume illegal drugs or marijuana. No alcohol, no drugs, no marijuana. Submit to chemical testing on demand of probation. We're going to start to pay for these tests. As long as you show and you show every time and you test negative every time, we will be paying for your tests with our grant. If you miss a test, I'm going to consider it a positive, I'm going to consider it to have been a positive test. And you're going to be subject not only to sanctions, but you're going to be paying for those tests for a while. Okay? So submit to chemical testing, PBTs and ETGs on demand of probation. You've been on the sober link for, correct me if I'm wrong, it's been about 2 months, right?
Yes, about that.
75 days more on the sober link device. Attend AANA 12-step meetings at least 3 times a week and provide proof of attendance. Obtain an AANA sponsor. Attend all substance abuse treatment as directed by probation. Attend the Victims Impact Panel. Attend the Armed Specialty Court Weekend Program. Report to sobriety court status review hearings with me every 2 weeks. You can come at either 7:30 or 3 o'clock. That's on Wednesdays. Although we're going to be moving the one on Wednesdays a little bit. So I'll make that's going to be Tuesday afternoons going forward pretty soon. You're to obtain and maintain employment with proof provided to probation. In terms of fines are going to be $200. Costs are going to be $200. $75 victims' rights fee, $50 justice assessment. So your fines and costs are only $5.25. Your screening fee is $60 for $585. You have probation fees of $480. Bringing your total to $1,065. Sobriety court fees are $360, bringing your total to $1,425. And then you have cost of recovery. This was a blood draw for $2.25. All right, so I'm sorry, Amy, what did I just say the fee, everything was until I added in cost of recovery? Can't remember. 200, 400, 5.25, 585, 985, 1,065, 1,365, 1,425. The total here will amount to $1,650. Now, there is a problem though. If you weren't getting in sobriety court, I think I made clear you'd be going to jail. Did I make clear of that? Yes.
Yes.
So I want you to know right now, you're saving yourself, but no violations. Okay?
Yep.
I'm going to order 10 days jail credit, 1 serve 9. I'll let you serve all 9 on the court work program. 9 days court work. 9 days of court work program at the rate of $35 a day amounts to $270, $315 plus the $1,650. I can't keep these fines and costs any lower. Or I just can't make them lower with all these fees that we have to add in. $1,965 is your total. If you violate, your probation could be revoked. You could be incarcerated for 93 days with credit for 1 day served. So that is the sentence of the court. You have 21 days to appeal. You have 14 days to apply for a court-appointed hearing for purposes of appeal. I look forward to helping you. I really do. How much of this, can he pay all of this today, Mr. Sparrow?
Yeah, could he have a payment plan?
All right, how much does he have today?
Today, I will have anything till Friday.
You get paid weekly, right? All right, I'm gonna give you a payment plan. When do you get paid next?
Friday.
This Friday?
Yes, sir.
Judge, he also has the outstanding PBT, just if you're including that in the payment plan.
On file B here, my apologies. Fines costs of 200. I'll make it 200. I'll cut them down a little bit. So not much, but fines cost of 200. And I'm gonna ask you to pay that one. Can you pay that by Monday?
By Monday, yes.
You pay that one by Monday, which is March the 23rd. And then I will set you up on a payment plan of $125 bi-weekly. Can you do that?
Yes.
You pay $125 bi-weekly, and I'm gonna start that beginning on April the 6th. Okay? That's it. You'll meet with probation. I think they're gonna cover some other aspects with you. We'll want to get the sober link changed over where we're paying for that now. Again, just make sure you're blowing into it and you're doing everything, okay?
Sir.
Good luck.
Thank you.
Thank you very much.
See you this afternoon.
All right, sounds good. Good luck.
Thank you.
Nolan. Terrell Nolan. What? Did you meet with the prosecutor, Mr. Holmberg?
He did, Your Honor, and Lieutenant Toller is bringing the file in right now.
Okay.
Yes, Your Honor, that's correct. We did.
Okay, 23B147631. Mr. Nolan, your name? I took your plea December 4th of 25. The charge was failure to complete the Positive Strategies Program at 4-week follow-up. What is going on here? Now the prosecutor's saying you request a month adjournment to complete it? This is March. Why haven't you done it?
I don't have an excuse.
Well, then, come on. I'm not gonna beg you to do these things. You don't wanna do it, don't do it.
I don't want to do this.
Well, no, you don't wanna do it. Listen to me. I sentenced you back on March the 13th to 25.
And ever since this all started, my life has changed, like 180. So I'm going through a lot of stuff, trying to do a lot of stuff and handle a lot of stuff. This did go over my head only because I just started 24-hour shifts. So it did go over my head, but it's not something that I did on purpose or intended to miss. That's why I show up every time there's a court date. I don't mean to do it on purpose, but I do want to get it done. That's why I'm asking for the extra time, because I'm already enrolled. My first date is on Monday the 23rd.
Call in the prosecutor, please. I don't understand. I just don't understand. I don't understand. I told you to do it December the 2nd. Well, this is March the 18th.
I did the first part of the class, and then, like I said,
I don't even know why the prosecutor has anything to do with this, to be honest with you, except this is a review hearing date.
Yeah.
I'm gonna need Caitlin Foley Carter. Did I take this under a statute? 771 maybe? Your name?
Caitlin Foley Carter, Bronson Township.
I'm not sure what's going on. Did I take this under a 771?
I believe so, Your Honor.
I don't know why I set a review hearing date. Amy, I need to check something.
I don't see that you took it under a special status.
Either. And it's a review, but I wrote down here to set a review hearing date, and it was set for March the 4th at 9 a.m. And I wouldn't do that unless I was taking it under a statute. Let me just double check something here.
It looks like Lisa made a note on 3/25 that said not taken under deferred status.
Oh, yeah. So he really shouldn't have even seen you. This is just a new show cause for failure to attend the Positive Strategies Program.
Understood, Your Honor.
That's so that I just need to be clear about that. I'm sorry. That probably was my fault. So I'm gonna go ahead and arraign you
Thanks, Jack.
I'll give you a lawyer if you want. You're charged with failure to attend the Positive Strategies program with 4-week follow-up. Says you attended the intake session but failed to appear for the follow-up appointments. If you plead guilty or if you were found guilty, this would be a second technical violation. And you could get 10 days. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form here today? If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that? All right. So you have the right to a lawyer. I'll be happy to provide you with one at public expense. Would you like a lawyer? Are you sure? To the charge, you failed to attend the Positive Strategies program with 4-week follow-up. How do you plead? You failed to attend the Positive Strategies program with 4-week follow-up. I can't hear you.
Yes.
Anybody force you to plead guilty?
No.
I need justice. So you went to the intake, correct?
Yes.
When was that?
I don't recall the initial date. I know it
Was it in 25 or 26? When was it? January, February?
I think it was, I honestly can't even. I'm sorry.
But you failed to attend and complete the program. True?
Yes, I think the first part, the 6-hour part, and then the next Monday session is what I missed due to.
All right. I'll accept your plea. I find it to be an accurate plea. Made voluntarily and understandingly. The plea is accepted. All right. Your name, please.
Let's vote on.
I don't know what he's doing. What is he doing here? When was the intake session?
The intake session he had, let me double check and see. So he appeared for his intake session back in January 22nd, and then missed the follow-ups as scheduled.
Where do you work?
Superior in Taylor, and then another station in Middleton. Be 24th at Taylor sometimes, and then I do 13 hours at
Doing what?
EMT on the ambulance. Literally just
You're an EMT and you're acting like this?
not like I said, since the first time I met you, I've been trying to change everything around.
What do you mean change everything around?
My life, just the path that I was going down.
What path were you going down?
I was just, like I said, I met you, I was going down a bad path. My wife was pregnant, about to get married, so I'm trying to turn everything around. I'm about to crunch this.
You're about to what?
No, I'm trying to just turn everything around to make it better for my health.
How old are you?
I'm 27, just turned 27 in February.
You're a well-spoken man. And you have been a year on probation and you're still playing around with this.
But I am playing around. I'm not trying to go. I'm trying to get it done as quick as I can. At least miss some opportunities.
What do you want to say?
Class is completed. It's only the class that's left for him. He completed all of his time, Prosser paid in full, completed all his coursework program days, he cleared his warrants up as ordered. It's just this remaining class, just the follow-ups. And from what I checked right now, that doesn't seem like the follow-ups are scheduled until May.
Oh no, they said the first one starts. It's Monday.
It's Monday, okay, perfect.
He was scheduled to come off probation on March the 13th, right? How many hours you working per week?
It's been like 40 to 60. I'll try to get as much time as I can because I gotta pay for the wedding. So that's in 4 months.
This is your last chance. Okay. Serve a day on the court work program, pay $30 for that. Probation is extended until June 13th for a period of 3 months. Additional cost is 60, additional probation fees is 60. Your total here is 155. Defendant to complete Positive Strategies program. You seem like a nice guy, but you gotta, I don't understand. get this taken care of, or I'm telling you, I'm not gonna be this nice next time. We understand one another?
Yes, sir.
I thought we understood each other last time.
You did it, man.
All right, enough said. Go down the hall, take care of that, talk to her. Good luck, and good luck on your wedding. Ramona Stokes, wait, which one's Mr. Palmer's? All right. You have a seat at the table, man. This is Adriana Giselle Verjagas. 26884032.
Yes, Your Honor. Yes, Your Honor. Edward Holmberg on behalf of the defendant. She's with me, Your Honor. She's sitting to my left.
Your name, ma'am?
Adriana Villegas.
So we've adjourned this at least
Twice.
This is the third time, right?
Yeah, and I just want to apologize, and this is my office's fault. We had it misdiaried. We had it for tomorrow. The attorney that's handling my partner, she had a hearing in Madison Heights this morning. I'm house counsel in Lincoln Park. I thought it was tomorrow. It's our fault. The defendant was here.
You don't have to grovel that much. That's fine. Give me a new date. Give me a new date, Amy, please. 2 weeks.
2 weeks is April 1st, Judge, at
8:30?
That's fine. Thank you. I'll make it work. You guys will deal with it. I
8:30
appreciate
in the
favor.
morning, April 1st. All right?
Yes, thank you so much. And I apologize.
Have a good day.
Bye-bye.
Thank you.
Hold on.
All right. Vito Express. 26884146 your name, sir?
My name is Rami Baki.
Are you the president of Vito?
I'm the owner.
All right, okay. So you provided, so this is a civil infraction, so I'm gonna let you appear, but if this was a misdemeanor, I couldn't, okay? So we're gonna move to dismiss. It says it's infected equipment. It says you provided paperwork. Case dismissed. Good luck to you.
Just leave.
You can just leave.
Thank you.
Have a good day. You're Ramona Stokes.
Yeah.
Come on up here. Ramona Janelle Stokes, 2688414658A. All right, how you doing?
I'm fine, how are you?
Your name?
Ramona Stokes.
You're charged with driving while unlicensed. Why weren't you here March 4th, by the way?
I didn't have funeral to attend that day.
You understand what you're charged with here?
Okay.
Correct. Would you like a lawyer? Okay, so I'll go ahead and arraign you. I'll explain the charge, the possible consequences, and send you to the prosecutor, okay?
Okay.
It is alleged that on February 7 of 26 that you did operate a motor vehicle while you were unlicensed. This allegedly occurred on West near I-75 in the city of Woodhaven, County of Wayne at 11:31 p.m. That is a misdemeanor punishable by up to $500 in fines, 93 days jail cost for all those. You understand that?
Yes.
You're also charged with a civil infraction of no proof of insurance. That is a civil infraction, 0-pointer, punishable by $185. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, actually, you went into default on that one, by the way, because you didn't show up on March the 4th. You needed to call us at least. I'm sorry about your rash.
No, and right after that, you guys sent out another letter, so that's why I'm here to listen.
Amy, have them call that civil infraction, will you please? And
Judge, it looks like that civil infraction is paid and closed.
you paid it?
Yeah.
Okay. We'll tell the prosecutor that, okay?
Okay.
So I'll enter a not guilty plea, $500 personal bond. You cannot leave the state without consent. You cannot violate a law unless the appear in court is directed. I'm gonna just make a note. Mr. West, tell the lieutenant that prosecutors there by Zoom, so they'll set you up.
Yes, Your Honor. Josh West appearing on behalf of the people. I did hear everything. I will work with her.
Thank you very much. I'm gonna send this file in to Lieutenant Toller where you guys can Zoom, okay? Thank you. All right, so you're gonna go right outside and then in that first door to your right. Don't go in there, that's lockup. Hibbs, Kevin Lee Hibbs, 2. Six W841841. Your name?
Kevin Lee Francis Gibbs the first.
All right. Okay, that's quite a mouthful. Good
Irish name.
All right, you're charged with disturb the peace. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer? Okay, I'll go ahead and arraign you and send you to the prosecutor. It's alleged that you did commit the offense of disturbing the peace in the city of Woodhaven at or near 22090 Loretta Drive near Middleton and Woodhaven. It says you threw snowballs.
A snowball.
Well, I'm just telling you what the ticket says.
I never got a ticket.
And slow down. Just let me finish. Let me finish. I'm just telling you what they said in the remarks. Defendant did breach the peace of Troy Marlowitz by throwing snowballs onto his property and striking his gazebo, leaving behind a reddish stain. That's what it says. That is a misdemeanor punishable. I'm not saying it happened. I'm just telling you that's what they think happened. It's a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, I do.
Did you sign, read, and understand the advice of rights?
Yes, I did.
If you plead guilty at any time, you'll be giving up all those rights. And we're not going to have a hearing or a trial. Do you understand that?
Yes, I do.
All
I
right,
have an explanation, sir.
hang on one second.
Okay.
Just hang on 1 second. This is not a trial today. This is just an arraignment. And I'm going to enter a not guilty plea for you. If you'll just bear with me 1 second. I'm going to give you some bond conditions. I'm going to give you a personal bond. You don't have to post any money. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're not to have any contact at all with the victim, Troy Marlowitz. Okay?
Yes, sir.
You cannot write him, phone him, see him, text him, email him. If I saw him outside and I was you, I'd go back in my house. Don't leave this to chance where somebody thinks that you're having contact. Are you with me? You with me?
I understand what you're saying, Your Honor, but the man lives next door. I can't avoid him.
Yes, you can. If he's outside in the front yard, don't be in the front yard. Yes, you can.
If I go in my backyard, he
Listen.
comes out into his backyard, I'm supposed to go in my house?
Yes.
Yes.
Yeah.
I'm a 72-year-old United States Army veteran.
Sir,
I'm a grandfather. I've lived in the city for over 40 years.
sir,
The man was 11 years old when I moved into that house.
sir.
And you're telling me I gotta go in my house when he comes in his backyard?
I'm telling you, you're not to have any contact with. I'm telling you that if you stay out there and then allegations are made, you're going to have some questions to answer. If I were you, listen to me. I don't want to argue with you. This is a standard condition. I don't know what happened. I don't know that anything happened. For all I know, you were in Tuscaloosa, Alabama on this
It's a
day.
snowball.
Sir, listen, I don't write charges. They don't talk to me in advance and ask whether or not they should charge somebody. This could be the worst charge ever in the history of American jurisprudence for all I know. I don't know. I'm just telling you, no contact. Because if I tell you you can stay out in the backyard if he's out there, then during the pendency of this case, he might start making accusations that you're talking to him, or you're saying something to him, or you're making gestures toward him that would amount to a violation of the no contact provision. Okay?
I do understand.
I'm saying you cannot write him, phone him, see him, text him, email him, or communicate with him.
Yes.
Now, I don't want to have to get any more if he's out in the backyard cutting his grass on the other side of the lawn, whether or not you should stay there. I'm just telling you what I would do. Then you will have no questions to answer. Okay? Are you with me?
Probably, yes, sir, but
It's okay that you disagree with me.
there,
You're not
there's cameras in my yard.
You're not gonna be the first one that walks out of here saying you disagree with. I've been doing this.
I don't disagree with you, Your Honor, but there are extenuating circumstances.
I'm not saying there aren't. I don't know one thing about this case. Other than what I read on the citation, and that's just their allegation. I'm not saying there isn't. You go explain your situation to the prosecutor right now. Who knows? Maybe he'll come in here and say he's gonna dismiss the case. I don't know what he's gonna say. That's up to you two. I don't have anything to do with that. Got it?
Yes.
All right, so go talk to him, see what you can resolve. If you have any more questions about the no contact provision, you can raise them when you come back in. Okay?
Yes.
All right, good luck.
Thank you.
People against. Lori Gale, uh, 2-6, Lori Gay, Hinkle, 2-6-7-8-4-1-1-3-0-8.
Morning, Your Honor, Michael Fall to Representative Benedict Procedural.
Ms. Hinkle, your name?
Lori Gainville.
Are you intoxicated?
No, sir.
Does she smell of alcohol? I don't want to put you in that position. Okay. She was drunk once when she came in here. I want to make sure. Are you good to proceed?
Yes.
You live in Flat Rock, right?
I'm currently living in Wood Heights. I got evicted from Flat Rock. I have a P.O. box.
And Amy, do me a favor. Will you look at the court to school day, March 26th, and make sure I only have one participant so far? I'm going to ask Mr. Crawford.
Judge, it looks like, I'm sorry, you
That's okay.
have 2 so far?
You want to be the third man? I have to have defendants sentenced at a school. It's more embarrassing. I'm not going to lie to you. There's only a couple of people in there right now. I'm going to do it at Shoemate Elementary School. Or Shoemate, yeah, it's Shoemate.
Middle school.
Middle school. If you would be so kind, I would like you to come back and do it on March the 26th at the middle school. I'm not going to make an example of you. It's going to be junior high kids. I need one more participant, but I need to know also, Mr. Crawford, that you can do that.
March 26th, correct?
That's a week from
I believe Mr. Crawford's already committed with one of his clients to attend.
Yes.
Do you mind doing that, ma'am?
No.
You won't let me down and not show up, will you? I need you to, so we're gonna do this court to school. It's gonna be March the 26th at Shoemate Elementary. What time do we start that?
9 a.m.
We're starting at 9, so give them a notice for 8:30, okay? I need you to get there and read the report with your lawyer. I really appreciate you doing this. I will give you credit for anything that I'm going to impose, like court work or community service or the like, okay? So you'll go down the hall, get your notice, and we'll give you a map too if you want. Give her a map too, if you would, Amy. Thank you very much.
Thank you.
I appreciate it. Good luck. Thanks, Mr. Crawford. And leasing.
Ready, Your Honor.
Let me see here. What do I got? I can't do this, guys. Mr. West, I need you. N Leasing Company, LLC, 26W841813A. There's only one file here, right?
That's correct, Your Honor.
Mr. West? Well, wait a minute. There should be 2 files. What happened to the expired plate file? I could do this then.
I understand.
I was only handed one file here.
And we had to go get the file, so you want me to go back and check?
No, I gave him both files.
Oh,
Yeah.
He must not have brought it in. I just need the B file, John.
Yeah. Try to follow it. I don't know if the figure's not ringing.
All right. What's your P number?
We're on the map, you want P 74329?
Okay.
I'm going.
Mr. Sherbo's got a 25 P number.
Mr. Sherbo has a 25 P number.
Mr. Sherbo's my partner. I am on the appearance originally, but the two P number always gets on the main ticket.
Well, because that's an old one.
That is an old one.
I mean,
When they shuffled them back.
that's probably back when he must have been a lawyer in whatever year they started. Was it '70s?
Right into the 60s, 70s, and I've been with Jeff for 15 years. My understanding is he shuffled it. So, because he always argues with everybody that he's been around longer, but he doesn't have a 1P number.
Well, because they did it by alphabetical
Yes.
initially.
Yes, but no, I do not have a 2P number.
All right, so I have M Leasing Company, 267841813, A and B. Now I have the second file. Okay, tell me your appearance again.
Morning, Your Honor. Matthew Wood, P74329 on behalf of the leasing company. I do have corporate authority to resolve this matter on the client's behalf. I had a chance to speak with the prosecuting attorney this morning, Your Honor, and subject to your approval, we'd like to tender a plea to responsible to 2 impeding traffics with dismissal of the A and the B ticket.
All right, first of all, for purposes of arraignment, you stand me away.
And you're reading the plead not guilty, Your Honor.
All right, so as to file A to the charge impeding responsible and not
On behalf of
responsible.
my client, I plead responsible, Your Honor.
On file B, responsible or not responsible.
Responsible, Your Honor.
This was a spill leak that they didn't cause damage on.
No, Your Honor, not from my understanding. And also the expired plate, I did bring proof that of what's it called, that we have the valid plates at this point, Your Honor.
All right, so I'm gonna accept the plea to impeding, dismiss the spill load, accept the plea to impeding on file B, dismiss the expired plate, $220 on each case. And they can pay by April the 6th. How's that?
That's wonderful, Your Honor. Your Honor, can we send one check in or should we send 2 checks?
Yeah, you can send one in with both A and B.
A and B ticket.
Yeah. Do I have to tell them anything else, Amy? No.
Nope, that works.
Everyone have a wonderful
You
day.
too. Thanks a lot. You too. Ramona Janelle Stokes. Chew. 6W841465A. All right, ma'am. Your name?
Ramona Stokes.
All right. You need some time to get your license?
Yes.
I'm gonna give you 4 weeks, okay?
So, I explained to him that when I got this ticket, that I guess they suspended the license until like April, but he said that I can come back and just show that everything is like cleared up, like as far as warrants or whatever that I had.
All right, well, I'm gonna give you 4 weeks to take care of everything, okay? So give me a date 4 weeks from now, if you would, Amy.
April 15th at 8:30 a.m.
Okay, April 15th at 8:30 a.m. You can go down the hall, we'll give you a notice.
Okay.
Any questions? Okay, good luck. Ma'am, what is your name?
She's an attorney.
I'm an interpreter with the University of Translators.
Okay.
It's a 9:45 case. He's not here.
Oh, boy. Okay, thank you. We'll get you out of here as soon as we can, okay? Anything else down there? All right. I'm going to take a break till we get something.
Thank you very much, Your Honor. Appreciate it.
Thank you.
Thank you. Can I go outside?
Sure can.
So he's not on Zoom. He's in person.
I don't know. What case do you have?
Albiyashi, Wasim, first name, Wasim Albiyashi is last name.
Okay.
It's retail firm.
Is he gonna be in person?
I'm not sure. He was scheduled for 8:30. If I'm reading the right one. Oh, no, I see. 9:45.
So we'll have to see
He
if
should be in person.
he's supposed to be in person. So you might want to have one of the court officers ask for that gentleman, will you?
Okay, I will ask and I will check it because I might recognize him for this look. Thank you.
Thank you.
Please state your name for the record. Jason Smith, good morning, Your Honor.
Good morning, sir.
Thank you, Judge. I did meet with Mr. Smith. He does have some other cases in circuit court pending. And we can adjourn this matter to the end of April or early May. We think we can get everything resolved.
What's my last date in April? What's my first date in May?
May 6th.
Turn the matter to May 6th, 2026, 9 a.m. Bond will continue.
Thank you, Judge.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Aisha Anderson.
Morning, Your Honor. Raymond Cook for the people.
He should be coming.
Oh. Well, let me do this. Court does call the case. I don't want to take it. They coming. Grace Anderson, that's you, man.
Yes, yes.
All right. Ms. Rushing? Okay. Ms. Rush? Oh, there she is.
Sorry, Judge, I was on the record in another court. Good morning, Your Honor. Sydney Rushing, appearing on behalf of Ms. Anderson. I am standing in for her attorney of record, Mr. Brandon Bird. And Ms. Anderson, is that correct? And with your permission?
Yes.
All right, very good. All
Your
right,
Honor,
what are we?
Your Honor, in this matter, all of Ms. Anderson's matters have been submitted to, I believe, the mental health court for consideration. We're asking for this case to tag along with those matters. So we're just asking for adjournment. I believe that you set her next PCC date out to, I believe, the beginning of April.
All right. So I'll adjourn this. I have April 1st.
Yes.
I'll adjourn this matter to April 1st, 2026, 9 a.m.
Thank you so much, Your Honor.
Thank you.
See you tomorrow.
Appreciate it.
Have a great day.
Two. Court calls the case of the People versus Penny Muldoon.
Your Honor, Raymond.
Good morning, Your Honor. Edward Drugas on behalf of Muldoon, who is approaching.
Hello, what's your name?
Penny Lynn Muldoon.
I have a plea form indicating that she's going to plead to an added count 2 of operating while visibly impaired, 93-day offense. Upon her successful plea to that charge, count 1 is dismissed. That's the court's full understanding of it.
That's correct, Your Honor.
Yes, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Penny Lynn.
Ma'am, it is this court's understanding that you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days of jail, up to a $300 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
In understanding that, you still wish to plead guilty
Yes, sir.
to that charge? How do you plead?
Guilty.
That you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Signed an advice of rights form, is that correct?
Correct.
Any questions regarding those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir. I understand.
You understand you're giving up your right to appeal upright.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And because you believe that you're guilty of this offense?
Yes, sir.
On the date of September 29, 2025, at the location of 5400 South State Street, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes, sir.
And that was cocaine?
I Someone gave me and I knew it was from the streets, a Percocet. So I didn't really know what was in it.
Okay, when you say somebody gave you something, you don't know what you took.
I believed it to be a Percocet, but I knew it wasn't.
Okay, but
It was not prescribed to
it
me.
was not prescribed to you,
Correct.
correct? Okay. Were you stopped by the police or were?
I was driving someone to work in the morning. I remember pulling away, not feeling very well, pulling off into the lawn, and that's the last thing I remember. I fell asleep.
So you were on South State Street and at some point you drove off the road.
I was in a parking lot of a factory.
And at some point,
Yeah.
operating the vehicle and you drove off the asphalt and onto grass.
Yes, sir.
To a grassy area.
Yes, sir.
All right. Did the police arrive?
Yes, sir.
Were you ultimately arrested?
They sent me to be tested.
Okay. So
They sent they drove me to the hospital to be tested.
Cuffs?
Yes.
Wearing cuffs?
Yes, sir.
You were probably arrested.
Yes.
Okay. So they took you to the hospital, right?
Mhm.
And then there was a blood test.
Mhm.
Yes?
Yes, sir.
All right. And did the results of that blood test indicate the presence of cocaine?
Yes, sir.
All right. Do you have any reason to dispute those blood test results?
No, sir.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was impaired due to your ingestion of a controlled substance?
Yes, sir.
Ma'am, I do have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
None from the people.
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendants referred to Bob's works for alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
At 12 noon.
April 29, 2026, 12 noon. Bond will continue.
Thank you.
All right, thank you. And stop down at my probation department on your left on your way out, please.
All right.
Thank you. Court does call the case of People versus Thomas Kumasaka.
Henriette Silver on behalf.
Kumasaka.
Good morning, Your Honor.
Your name, sir?
Thomas Kumasaka. Your Honor, I'm asking for an adjournment in this case. He has a next Thursday. And my understanding, there's going to be a resolution on that day and it's going to resolve our case. So if we could adjourn it till after.
April 1st.
Thank you.
2020, 9 a.m. bond continue.
Thank you.
Thank you. Court calls case People versus Austin North.
For the people. Henriette Silver on behalf of the township.
It's gonna rain on this.
Okay.
Good morning, Your Honor. Robert Ellman with and on behalf of Mr. Norton. In terms of the arraignment, we would stand mute and wait formal reading. But Mr. Norton, can you please state your name for the record?
Austin Norton. We wait formal reading, standing mute. Court will enter a not guilty plea. What are we doing?
Your Honor, Mr. Siller and I are working on a resolution of this case. We need a little more time to get some of that paperwork done. I'd be asking for a little bit longer of an adjournment if you would to
April 15th work.
Yes, sir.
Adjourn the matter to April 15th, 2026, 9 a.m. That's the defendant's bond. His bond will be set in the amount of $5,000 personal recognizance bond all of the standard conditions, including no assaultive behavior and or possession of any weapons or ammunition. You understand that, sir?
Yes, sir.
And I'm also going to order at this time no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. You understand that? Okay. Thank you. Court calls case People versus Christian Bird.
And it's still around the game. So, township.
Very good. Marshal Feaster, Assistant Public Defender, on behalf of Christian Bird, who is approaching the podium. When you arise, please state your name for the record.
Christian Bird.
Thank you.
Thank you, Judge. I did meet with Ms. Bird yesterday, and I did speak to Mr. Chablowski, who has her case up for tomorrow in front of you for PCC. We're working on a global resolution. Brief resolution, please, Judge. Brief adjournment.
Adjourn the matter April 1st, 2026, 9 a.m. Bond continue.
Thank you.
Thank you.
All right, later. Thank you.
Court calls the case of the People versus Joshua Wara.
Morning, Your Honor, Raymond Cook for the people.
Good morning, Judge. Larry Margolis with and not with, but on behalf of Mr. Wara. Let me give you an update, Judge, for what went down since you modified the bond. Josh was released into the custody of U of M ER. He is now presently at Havenwick Hospital. I've been advised that his stay is 7 to 14 days, but I'm working on obtaining the admittance or discharge paperwork from U of M, and I will provide it to your court staff. I'm asking for 2 to 3 weeks adjournment.
Without objection, April 1st, 2026, 9 a.m.
Thank you, Judge.
Thank you.
Bye.
Court calls the case People versus Norman John. Norman Johnson.
Your Honor,
Sherilyn Foster Tucker on behalf of Norman Johnson.
Norman Johnson. Thank you.
Your Honor, we're requesting an adjournment. He has a case up at Circuit Court and we're hoping to work out a global resolution.
Who's that?
I think his next pretrial is Monday.
Monday of this
20. Yeah.
April 1st, 2026, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls the cases of the People versus Ryan Brown.
Your Honor, Raymond Cook for the people filing.
Ron Brown appearing on behalf of Ryan Brown.
Still around the game. Yes, it's still township.
Ron, case 610 is in arraignment.
Which one?
610.
Here. Ryan Brown. No response. Bench warrants will issue for the defendant's failure to appear in each of these matters. Bond will be set in the amount of $5,000, 10% on each case. Those warrants will issue immediately. Court calls the case. Yeah. Great. And can you contact Paul, make sure he's gone? Court calls case People versus Justin Randolph.
Your Honor, Raymond Cook file ending in 0556.
And it's still around the game. It's still township.
For the Judge, Torshall Feaster, First Assistant Public Defender, on behalf of Mr. Justin Randolph, who I do not believe is going to be present, Your Honor. There was a progress report that was sent to our office that indicated that Mr. Randolph County Jail via VineLink.
What?
They believe that he was in the Livingston County Jail. It's on a VineLink search.
Okay, and he remains there.
Yes, Judge.
Okay. Want me to adjourn him out?
Yes, please.
We can try to do that. I'll adjourn these matters April 1st, 2026, 9 a.m.
Thank you, Judge.
Bond will continue in these matters. Court does call the case People versus Reese Palmer.
Your Honor, Raymond Cook, please.
Your name, sir?
My name is Reese Palmer, sir.
The PD.
It's a public defender case. Well, they don't have all this too. But
Ready, Judge. Torshall Feaster, first assistant public defender. On behalf of Mr. Palmer. Nice to meet you, sir. Please state your name for the record.
Reese Palmer.
He even been arraigned. He is not.
Oh, that's my mistake.
All right.
On today.
All right. What are you gonna do today?
I'm gonna adjourn your court and arraign you. He's looking at you. We're ready, Judge. Did you say you had to arraign him?
No, he's been arraigned.
Okay, thank you, Judge.
Well, sir, this is what I'm trying to do. I got stage 4 cancer, sir.
Pardon?
I got stage 4 cancer. When I caught this case, sir, when I got this case a year and a half ago, almost 2 years ago, whenever it was, I was homeless. Now I'm not homeless. I'm on disability. And I can't take chemo while I'm in the county jail. So please, I'm trying to get a personal reconnaissance bond so I can get out and take my stage 4 chemo. This is the last chance I got. If this don't work, then definitely I got to go see God.
All right.
I guess that's his bond request, Your Honor, and he's requesting a.
Well, if I can get information, I'm not going to have a problem with the release.
Okay. He needs some proof.
Does he have other cases pending?
Your Honor, I see he has another case set for PCC tomorrow with $1,000 category bond. I'm trying to open that shell right now to see if there's any out of county holds. I would also, looking in our system, I do see there's 2 new cases with dates of offense, February 21st and March 10. I have not reviewed those, but it looks like they have been requested for charges as well.
What I'll do is I'll adjourn this matter to April 1st, 2026, 9 a.m. And if I can get medical, then we can try to figure out how, what terms we
situation. Reach out to me after court today. We'll address the bond.
Thank you.
Thank you, Judge.
Court does call the case People versus Rahman Khan.
I don't have it. Ready, Judge. Torshall Feaster, assistant public defender on behalf of Rahman Khan, who should be present by Zoom. Tom, state your name for the record.
Rahman Khan.
I have before me a plea form that indicates pleading guilty to this. Well, I don't know what this means. Pleading to 2 and 3.
Yes, Your Honor, there should be 3 counts on the complaint. Essentially, counts 2 and 3, count 1 to be dismissed.
Got it.
The pleas being taken under fight up.
That is all correct, Your Honor.
All right. And that's what the form does reflect. Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name for the record.
Rahman Khan.
All right, you can put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to 2 charges of malicious destruction of a building, $200 to it, but less than $1,000. Those 2 offenses are misdemeanors punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased if 3 times the value of the property destroyed or otherwise injured is greater than $2,000. Do you understand that, sir?
Yes.
All right. And understanding all of that, do you still wish to plead guilty?
Yes.
To the charge of malicious destruction of a building, 200 to 1,000 as contained in count 2, how do you plead?
Guilty.
To that same charge as contained in count 3, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form or had one signed on your behalf?
Yes, I signed it.
Have any questions regarding any of those
No.
rights? Looking at paragraph 5, those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty of these offenses?
Yes, Your Honor.
March 13, 2023, at the location of 4499 Hunt Club Drive, Pittsfield Township, Washtenaw County, State of Michigan. What did you do to the premises located at 4491 Hunt Club Drive and the premises located at 4499 Hunt Club Drive that makes you think that you're guilty?
I broke 2 doorknobs and damaged the apartment building door.
Okay. So you broke 2 doorknobs, one to each of those units?
Yes.
Okay, as well as another knob that I guess was the one leading into the building, probably?
Yeah.
Correct? Okay.
Yes.
You don't have any property interest in either one of those?
No.
All right. And your breaking of that was in you did that intentionally. Is that
Yes.
correct?
Yes, Your
All
Honor.
right. And was it just the doorknob?
It was 2 doorknobs, and for the second doorknob, that was the door to the apartment building.
So you damaged the door also.
Yeah.
For each one of those items that you damaged, do you believe that the damage in each of those 2 incidents was in excess of $200?
I believe so.
Counsel, you stipulate that the amount of damage is $200 on
We do, Your Honor.
All right. Sir, I have to advise you that if you commit misconduct between the time that I accept your plea and the time of sentencing in this matter, as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
Why is this set today?
It was added, Your Honor, because it was set for final settlement conference, and Mr. Khan is out of state, and to avoid him having to get here.
Got it. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
It's on the record, Judge.
And have I complied with the court?
Yes, Your Honor.
You have, Judge.
Court will accept the defendant's plea of guilty to counts 2 and 3. Count 1 is dismissed. Defendant's referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
At 12 noon.
April 29, 2026, noon.
Thank you.
And do I have, all right, Mr. Khan, wait on the line. We're going to put you into a breakout room with my probation department so we can begin the sentencing process. Understand that, sir?
Yes, thank you.
Thank you. Court calls the case People versus Austin Knox.
Honor Raymond Cook for the people.
Portia Feaster, Assistant Public Defender on behalf of Mr. Austin Knox, who, there he is on Zoom. State your name for the record, sir.
Austin James Knox.
Thank you.
Thank you, Judge. I did speak to Mr. Cook about this matter. Looks like there is an offer open. I believe Mr. Cook is keeping that offer open. Ask for the next court date to try to get it resolved, Judge.
Adjourn it to April 1st, 2026, 9 a.m. Bond continued. Thank you.
Thank you, Judge.
Thank you.
Court calls case People versus Carlos Mack.
Honor Raymond Cook for the people.
Thank you, Judge. Portia Feaster, Assistant Public Defender on behalf of Mr. Mack, who's approaching the podium. When you arrive, please state your name for the.
Carlos Mack.
Judge, I believe you may have indicated this was the last adjournment last time, so we'd ask this matter be set for final settlement conference and jurisdiction, please, Judge.
Jury final settlement conference will be set April 10th, 2026, 9 a.m. Jury selection. will be set April 13th, 2026, 8:30. Both of those proceedings are in person.
Thank you, Judge.
Thank you. Court calls case of People versus Mary McIntosh.
Bring the people.
Ready, Judge.
Or Mark McIntosh, I'm sorry, I didn't say Mary.
Yes, the court shall officer assistant public defender on behalf of Mr. McIntosh. Leave Mr. You are right now?
Yeah,
Okay, all right.
I just wanted the court to know.
Okay. Looks like we're gonna end up getting this matter resolved, but I need a new date to do so. Mr. McIntosh indicates he is in drug court in Monroe County, and he wants to resolve this matter now as a result of that, Judge.
So April 1st to be enough.
That should be fine, Judge.
During this matter, April 1st, 2026, 9 a.m.
Thank you, John.
Court calls the case of the People versus Chauncey.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Milligan, Your Honor.
Touching Milligan.
I have before me a plea form that indicates that you're going to plead guilty to the charge of retail fraud, second degree, the 1-year offense. On a successful plea, that is as charged. And that the prosecutor will recommend no upfront jail. That's the court's full understanding of the.
Yes, Your Honor.
I haven't, Joe.
Probably swear affirmative. Anybody will be through the whole.
Yes.
Station there.
Touching Milligan.
Mr. Milligan, it's this court's understanding that you're going to plead guilty to the charge retail fraud, second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that could become the maximum fine. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
To that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right, you signed an advice of rights form?
Yes, Your Honor.
Question regarding any of those rights?
No, Your Honor.
Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as other rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promise you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty?
Yes, Your Honor.
On the date of March 30th, 2025, location 3749 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan. What'd you do at the Target store that makes you think that you're guilty?
Took items I was for sale
Without paying
without
for them
paying for them.
and left the store.
Went in the store,
Yes, Your Honor.
took some items, trying to take them out of the store,
Yes, Your Honor.
and store was open to the public at the time.
Yes, Your Honor.
You didn't have anybody's permission to take that property.
No, Your Honor.
All right, the property that you were taking was something Target had offered for sale.
Yes, Your Honor.
All right. And I don't think this is done on value. Had you previously been convicted of retail fraud on or about, I saw the date of September 25th, 2019 in this court?
Yes, Your Honor.
Okay. I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Counsel aware of any other promises, threats, or other inducements which led to this plea?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty in this case. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing will be
April 29th at 12 noon.
April 29th, 2026, 12 noon.
Thank you.
Thank you. Court calls the case of the People versus Whitney Mitchell.
Morning, Your Honor. Raymond Cook for the people.
I'm appearing on behalf of Whitney Mitchell.
Whitney Mitchell.
Thank you.
You're
Your Honor,
welcome.
I'm requesting an adjournment. We're trying to get her in sobriety court. She's had an assessment.
She's had an assessment.
Yes, she has. I talked to the person who did it. It was back in early February.
During the matter, April 1st, 2026, 9 a.m., because I keep adjourning this out and I'm not getting anywhere. So I have to figure something out.
Understood.
Court calls the case People versus Omar Muhammad.
Your Honor,
Rod Robinson on behalf of Omar Muhammad.
Omar Muhammad, Your Honor.
Thank you.
Your Honor, I'm requesting an adjournment to talk to the prosecutor.
April 1st, 2026, 9 a.m. Bound continue. Thank you, Mr. Muhammad.
Thank you, Your Honor.
Court calls the case of the People versus John Neary.
Your Honor.
Where's the Fort Shell Police or Assistant Public Defender appearing on behalf of Mr. Neary, who is approaching the podium? Please state your name for the record, sir.
John Neary.
Thank you,
Morning,
Judge.
Your
You should have a plea form.
Morning, Al.
I have a plea form that indicates that he's going to be pleading no contest to the charge of assault and or assault and battery. 93-day offense upon his successful plea to that charge. That is as charged, actually. And there's an agreement to prosecutors to vote.
That's correct, Your Honor.
This is correct, Judge.
May I have him sworn?
Raise your right hand. Affirm the testimony about the truth, the whole truth, self you got it.
Yes, I will.
Thank you.
John Neary.
There it is, this court's understanding. You're going to be pleading no contest to the charge of assault and or assault and battery. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, sir, I do.
Do you understand what a no contest plea is?
Yes, sir.
All right, two things about it. I have to make sure you understand it. First of all, means that you're not further desirous or wanting to contest this charge. Do you understand that?
Sir.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes, it just means that.
Yes, sir.
All right. Basis for the no contest plea.
Potential liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir, I do.
All right, you signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding those rights?
No, sir.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
Understand you're giving up your right to appeal of right.
Yes, sir, I do.
Are you on probation or parole?
No, sir, I've never been.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce?
No, sir.
Doing this voluntarily
Yes, sir.
and of your own free will?
Yes, sir.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25-12957. Any objection to the court having reviewed that report?
No, sir. No.
No, Judge, we see purpose of plea.
Pardon?
We stipulate to it, Your Honor, for purpose of plea.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you, if you're between the time I accept your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and you would not, the court would no longer be bound by any sentence evaluation or recommendation. You understand?
Yes, sir, I do.
All right. Counsel, you're aware of any other promises, threats, or other inducements that have led to this point?
None from the people.
It's all on the record, Judge.
And have I complied with the court rule?
Yes, sir.
You have, Judge.
Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be April 29th, 2026, 12 noon. Bond in this matter will continue.
Judge, I'll have him check in at
Thank you.
probation.
Yes, sir.
All right.
All right.
We're gonna go now.
Sir,
Yes, sir.
you know my question. How's your wife doing?
Man, she ate her first cheeseburger two weeks ago, and it was incredible. She didn't say nothing. She just sat over there in her own little corner and smiled, and it was I guess it was an experience. You know, she ain't been able to do it for 5 months. So
5 months, right? Okay.
crazy.
All right.
Yep. It was yeah, it's good.
Okay.
It's getting better. Definitely getting better. I thank you for your patience and everything you've done for me too.
All right. Well, give her my best, please.
Yes, sir. I always, sir.
Court calls the case, People versus Walter Peterson.
Your Honor, reading for the people.
Good morning, Your Honor. Robert Ellman on behalf of Mr. Peterson, who I believe they're zooming in from the county jail right now.
Mr. Peterson, can you state your name?
State your name.
Walter Peterson.
All right.
So, Your Honor, the people and I have reached a resolution in this matter. You don't have a plea form. Unfortunately, I thought Mr. Peterson was going to be here in person this morning to be able to sign that form. The resolution was to plead guilty and have a sentence agreement to time served. I'd be happy to sign that on his behalf if you'd allow. Otherwise, I'd be at.
You haven't gone through his rights, so.
Yes, I mean, we've talked about it, but I don't have a signed advice, right, Your Honor?
See, and on something else.
Yes, Your Honor. He does currently have 2 other felony matters before Your Honor.
I'll adjourn it out April 1st, 2026, 90. Bond considered.
Thank you, Your Honor.
He said.
Got it. Okay, that's fine. Court calls the case of the People versus Craig. The Rosecrans.
Your Honor, reading for the people.
Ron Brown appearing on behalf of Rosecrans.
Sir, state your name.
Craig Rosecrans.
All right, thank you.
Your Honor, I'm requesting an adjournment. He is in treatment.
Where?
This is Mr. Feaster's case. I'm just standing in.
Sir, where are you in treatment?
I'm at Dawn Farm downtown.
Gotcha. All right. I'll adjourn it to April 15th, 2026, 9 a.m. All right, sir.
Thank you.
Thank you, sir. Court calls the case of the People versus Latwalia Salisbury.
Your Honor, reading.
Ron Brown appearing on behalf of Ms. Salisbury.
Oh, hello, state your name.
Latwala Salisbury.
Thank you.
You're welcome.
Your Honor,
I actually got the name right.
I'm standing.
I'm pretty proud of me. Go ahead.
For Mr. Requesting adjournment. I'm standing in for Mr.
All right. I'll adjourn the matter. Well, they attempting to try to see whether they're attempting to try to get insurance or what's happening here. Okay, why don't
I believe it.
Go ahead.
I'm sorry. I was gonna say she called me and asked me if I had my insurance. I do have my insurance, so I believe that was the issue here.
Got it. It was part of, okay.
Yep, I got it.
Just trying to figure out where to adjourn it to. So I'll adjourn it to April 1st, 2026, 9 a.m. Let you get that information over to your attorney and then we can go. Okay?
Thank you.
I sent it over this morning. I don't understand.
Well, they probably had a lot of other things going on. So I don't know if they've seen it, okay?
Okay. Thank you.
All right, thank you.
Bye.
Bye-bye. Court does call the case of the People versus Erica Scott.
Your Honor, reading.
Ron Brown appearing on behalf of Ms. Scott. Ms. Scott, are you on the call?
Erica Scott, no response. Bench warrants will issue for defendant's.
Your Honor.
As it relates to the final and 761, I believe that's a no insurance. I received proof of insurance. Had the defendant appeared today, I was going to move to dismiss. If the court would waive her appearance, I would still make that motion to dismiss, at least the no insurance.
I've been in contact with her.
So you received the insurance?
Yes.
All right. So any objection to the 1761 being dismissed?
No.
That case is dismissed. Thank you, Mr. Cook.
Your Honor, will you hold a warrant I've been in communication with her. That's how I got.
Why isn't she here?
We sent her the Zoom.
Bench warrant will issue for defendant's failure to appear. Bond 5,000. 10%. Warrant issue immediately. Court calls the case of People versus Dave Short.
Ron Brown appearing on behalf of Mr. Short. I believe prosecutor going to dismiss this case as he has a valid license.
And that was my understanding. Well, I don't know if Mr. Short is here and can.
He might be on the phone. Mr. Short, is that you?
Yes, this is David Short.
All right, thank you.
People want to dismiss.
This case is dismissed without objection. Thank you, sir.
Objection.
Thank you, Your Honor.
Court calls the case of the People versus Jayland Washington.
You're reading clerk for the people.
For the judge, First Assistant Public Defender Torshall, on behalf of Mr. Washington, who I do not.
Right behind you.
Okay, awesome.
We don't. I can.
Thank you, Judge.
I was going to let him sneak up and just grab you.
You was gonna scare me, Judge.
What?
I have not spoken to Mr. Washington.
Apparently so.
Obvious, Judge. My intern. Judge.
State your name, please, sir.
Jayland Washington.
Thank you. I'll adjourn this matter April 15, 2026, 9 a.m.
Thank you.
Fine. Thank you, sir.
I'll give you the card so you can give me a call. Okay.
Court calls the cases of the People versus Keontae Wright.
Ready to Judge Torshall, Feaster, Assistant Public Defender on behalf of Mr. Washington. Mr. Wright, excuse me.
Mr. Wright. That was Mr. Washington.
Mr. Washington. I had not said.
Soon, and he's in 0134, I have his in arraignment.
Keontae Wright. Really?
All right, please unmute and state your name.
Keontae Wright.
I missed it.
All right, I need a camera, please. Said 134.
Yes, sir. Just all over the place.
Shoot. Oh, there. State your name.
Keontae Wright.
All right. Ma'am, you, other than the other case, you are also before the court on a complaint that alleges that on or about December 3rd, 2025 at 7,000 East Michigan Avenue, that being the Walmart, that you did commit the offense of retail fraud in the second degree. Do you understand the nature of that charge, ma'am?
December 3rd.
Do you understand the nature of that charge? ma'am?
Yes.
That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased as 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, man?
Yes.
First question I have for you on that case is, do you wish to be represented by an attorney?
Yes.
It's a public defender case.
Thank you, Judge Torshall, Feaster, Assistant Public Defender. Now, on behalf of Ms. Wright on the case in 0134, we stand mute and waive any further, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Bond in that case will be set in the amount of $5,000. Personal recognizance, alert of standard conditions, including no assault to behavior or possession of any weapons. I will indicate that the defendant does not possess and or consume any alcohol, recreational marijuana, or any illegal drugs. Is also, I would indicate, he is not to go to any Walmart store in the state of Michigan.
Thank you, Judge.
May I request one additional condition as part of that motion?
Sure, certainly.
I would request a no contact order with Zachary Cook, no relation. It's a loss prevention agent or an employee of that Walmart. The defendant allegedly threatened to pepper spray him when he attempted to confront her for this offense.
All right.
No objection.
That Cook with an E or?
No, it's just.
No. All right. I'll indicate also there's no contact with Zachary Cook. All right. What are we doing on these matters?
Thank you, Judge. In light of there being a new case, Your Honor, and the possibility of finding there be asked for an adjournment of both files, Your Honor.
Adjourn these matters to April 1st, 2026, 9 a.m.
Thank you, Judge.
Thank you. Court calls the case People versus Sean Moyer.
Your Honor, Raymond.
So, your name, sir?
Don Moyer.
Mr. Moyer, you are before the court on a misdemeanor complaint that alleges that on or about October 8th, 2025, Michigan Avenue near Fosdick Road in Pittsfield Township, Washtenaw County, state of Michigan, that you did commit a moving violation which caused serious impairment of bodily function. You understand the nature of that charge?
Yes, Your Honor.
That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that, sir?
Yes, sir.
All right, first question I have for you, sir, is do you wish to be represented by an attorney?
Yes.
Where are they? This is a public defender case.
Ron Brown appearing on behalf of Sean Moyer. Waive reading, standing, press trial, please.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. I'll adjourn the pretrial in this matter April 1st, 2026, 9 a.m. Set the defendant's bond as a personal recognizance, $5,000 bond. I'll order standard conditions, including no assaultive behavior or possession of any weapons or ammunition. There should be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand all of that, sir?
Yes, sir.
All right.
Sir, have a seat.
Thank you.
I want somebody from
Court does call the case of People versus Shannon Payne.
Your Honor, Raymond Cook to the people.
Hi, John Payne.
This is
So Nigel Payne. No response. I'll issue an order. Well, no, given the nature of the charge, bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give 10% privilege. That warrant will issue immediately. Court calls the case of the People versus Gracious Phillips.
Cook to the people.
Hello.
Hello,
What's your name?
Gracious Phillips.
You are before the court on a misdemeanor complaint that alleges that, if I can get to it, that alleges that on or about December 28, 2025, at the location of I-94 near Platte Road, Pittsfield Township, Washtenaw County, state of Michigan, that you did operate a motor vehicle with a high blood alcohol content. Do you understand the nature of that charge, man?
Yes, sir.
That is a misdemeanor punishable by up to 180 days incarceration, a $700 fine plus court costs. Court could order community service or any rehabilitative programs the court deems necessary. The court could also immobilize your vehicle, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental service. Do you understand all of that?
Yes.
First question I have for you is, do you want to be represented by counsel?
Yes.
It's a public defender case.
Good Judge. Worship, Assistant Public Defender on behalf of. Say your name for me.
Gracious Phillips.
We waive any reading, Your Honor, and stand mute.
Defendant never waive formal reading, standing mute. Court will enter not guilty. Okay.
We'd be asking for an adjournment, Your Honor, to try to find a resolution of matters.
Pretrial in this matter will be due April 1st, 2026, 9 a.m.
Yes.
Bond in this case, alleged BAC.
Like 71 Friday instead.
So bond will be set in the amount of a $20,000 personal recognizance bond, all other standard conditions, including no assault to be them any weapons or ammunition. Understand that, ma'am?
Yep.
That a yes?
Yep.
I'll also order that there's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. You understand that?
Yes.
I'm also going to sign a community corrections order. You're to report to the Department of Community Corrections for placement on a sober link testing device. I've signed that order. Best that you stop over there on your way out today. Understood? All right. Thank you.
Thank you very much, Judge. When did you just fill this out?
Court does call the versus Anthony Rabago.
Morning, Your Honor, Raymond Cook for the people.
Your name, sir?
Anthony Rabago, Your Honor.
All right. Sir, you are before the court on a misdemeanor complaint that alleges 2 counts. It alleges that on or about December 7th, 2025, at the location of I-94 near US 23 in Pittsfield Township, Washtenaw County, State of Michigan, count 1 alleges that you did operate a motor vehicle with a high blood alcohol content. Do you understand the nature of that charge, sir?
Yes, Your Honor.
That's a misdemeanor, punishable by up to 180 days incarceration, up to a $700 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. Could order your vehicle immobilized. Could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
Count 2 alleges that on that same date and at that same time that you did possess an open alcohol container in a motor vehicle. You understand the nature of that charge, sir?
Yes, Your Honor.
That's a misdemeanor, punishable by up to 90 days incarceration, $100 fine plus court cost. Court could order community service and any substance abuse screening. You understand that, sir?
Yes, Your Honor.
All right. First question I have for you, sir, is do you wish to be represented by an attorney?
Yes, Your Honor.
This is a public defender, yes.
Ron Brown appearing on behalf of Mr. Rabago, wait, reading, stand mute, request adjourned pretrial. May I address bond?
Defendant having waived for reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to April 1st, 2026, 9 a.m.
Your Honor, Mr. Rabago is 20 years old. He's a high school graduate from Glass City Academy in Toledo, Ohio. Marine Corps veteran, has employment in a warehouse down there. He's a full-time student studying software engineering at Western Governors University, no criminal record. His mom is present in court today with him. Your Honor, he lives in Toledo, but he will comply with any conditions of bond imposed by the court. I would ask for a personal bond with conditions.
Alleged being is
173 was a single motor vehicle.
Marine Corps.
Yes, sir.
How long were you in?
A few months, sir.
Bond in this matter will be set, or bond in this matter will be set at a $20,000 personal recognizance bond on order standard conditions, including no assaultive behavior or possession of any weapons or ammunition. I'm also going to indicate that you are not to possess any alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Yes, Your Honor.
I'm also going to order that you report over to the Department of Community Corrections for placement on a sober link teller testing device.